All right, so that everyone knows they're a little short on the floor, so it may go a little slower tonight than it usually does, but you got to be patient. You got to be patient with the deputies, okay? So they're doing the best they can. So we'll be patient with them while they grab folks off the floor. But let's do this. So do we have Miss Lawrence yet?
Yes, medical judge.
Okay, here we go. So we got our court reporter. Do we got Bostic? Where's Bostic? There's Bostic. I see her. Madam Court, we got Miss Gandy, Jamie. All right, so we'll start with Miss Lawrence. That's position one. Bostic, 22 CP 208336. Lawrence, been 240 days without an indictment, $80,000 good bond. I'm sure you're going to waive sounding. Whoever's representing Miss Lawrence, am I right?
Good evening, Judge Manning. Hannah Rondon here for Miss Lawrence.
You're going to waive sounding?
Yes.
Okay. And it's $80,000 good bond as of September the 19th. Wow.
Judge, in regards to Miss Lawrence on the prior arrests.
Boom. All right, go ahead, Miss Rondon.
All right, we are asking for a reduction in the $80,000 bond as Miss Lawrence cannot afford that amount. Miss Lawrence is 22 years old and has lived in Georgia for several months, I believe 9 now. She moved here in February from Miami, Florida to be with her boyfriend and to be closer to family. When she makes bond, she will reside at 5567 Everglades Trail, Norcross, Georgia, 30071 with her uncle-in-law, Paul. While residing there, she will have the support and care of her in-laws and extended family. Her boyfriend, the co-defendant in this case, would not be residing at that address and they would not have any contact. Ms. Lawrence has no prior criminal record and she has no history of failing to appear for any required court dates. Furthermore, there is no indication that Ms. Lawrence would intimidate any witnesses. She does not know where the witnesses live, nor does she have any way to contact them. As of today, Ms. Lawrence is only days away from giving birth. She's excited to meet her baby and she's committed to doing whatever she needs for the welfare of her child, the minimum of which would include compliance with a bond order. Thank you.
Miss Amjadi.
Your Honor, I believe Deputy Winfrey will be handling this matter for the state. Thank you, though.
All right, where's Deputy Winfrey?
Good afternoon, Judge Manning.
Ah, there you are. Okay. All right, go ahead. This is it's $80,000 good bond so far. Go ahead.
Yes, Your Honor. We would argue that there's been no significant change in circumstance to warrant a downward, I guess, reduction in her bond. I would like to note for the court that Ms. Lawrence does pose a significant risk of fleeing the jurisdiction. She has no significant ties to the state. She's actually from Delaware, and the address, the 5567 Everglades, I believe that is a hotel. It's important to note that her co-defendant that she mentioned, that the counsel mentioned as her boyfriend, participated in these acts that happened with the 2 victims involved in this case. We believe that her coming here was for the purpose of what they were involved in. That's on the warrant, and I won't go into what that is. But Your Honor, we believe that the $80,000 good bond is an appropriate bond for a case like this. It has substantial evidence, which is why it'll be indicted within the next 30 days. We've been working diligently because there's so much evidence in it. But Your Honor, we believe that the $80,000 good bond and is sufficient to secure Ms. Lawrence's presence when it comes to moving forward with this case. So we ask that the court not modify the bond.
All right, Miss Jamie, you can see my other bond, my bond order. I think I put that on there. All right, no drugs, no alcohol, no weapons, no further contact. And you can write out the names, Miss Jamie, on the no further contact, but I'll just say the initials SK and AH, and you can just write out the names like that was on the bond order. Stay away from 12655 Deerfield Parkway in Alpharetta. No social media, no further contact with anyone under the age of 21. No contact for your co-defendants, Christina Allen, Ammi, Summer Golden, Javaris Chestang, Chestang, Emily Brownstein, Deja Green. You're going to have an ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, and attorney visits. Let's see. Also, I think I did put on here before that the ankle monitor can be removed once she goes into labor. Then it just can be placed right back on afterwards. If she's made bond, then she needs to go back and have it placed back on. If she's still incarcerated, obviously the jail can have it placed back on her ankle.
Judge Manning, I did want to confirm that the address I gave is in fact a house.
Okay. And that's in DeKalb County, right? Or Gwinnett?
It's in Norcross. I have to look up the exact county.
It's Gwinnett.
Yeah, Gwinnett. There you go. All right. And stay out of Fulton County unless she's here for court or to see her lawyer. Ma'am, that means don't get gas in Fulton County. If they take you to Fulton County Hospital to have the baby, leave Fulton County once you get there and go back. All right, I'll go ahead and reduce it to 30 and 30, $60,000 good bond. Best of luck to you, ma'am.
Ron, that concludes my business with the court. May I be excused?
Absolutely. Good to see you. Have a good holiday if I don't see you again.
Yeah, you too, Judge. Thank you.
All right, let's see. So did we figure out what we're going to do with Anthony Cantu DeVille? Ms. Bernard's not on here, is she?
No, Judge. Ms. Rondon, I believe I sent you an
Yes.
email regarding that case.
Ms. Rhonda, do you know that case? It's Anthony Cantu DeVille, D-A-V-I-L.
It was my understanding it was a PD case.
And they say it's conflict.
I can look into it.
Okay, well, I'll tell you what, there's another case for that person on tomorrow. And this one has a bond. Do you want us to just reset it till tomorrow?
Yes, please. We would appreciate
Okay.
that.
All right, so we can reset that one till tomorrow. Okay, so do we have Cobb County? Do we have Warren Watley? Mr. Watley? Thank you. Let's see, this is 22 CP 212-377, 89 days without indictment, possession of firearm by a convicted felon, driving with license suspended or revoked, expired license plate or decal. Wow.
In regards to Mr. Watley, numerous open cases, 22 CP 208-748, entering auto, 22 CP 212-377, firearm by convicted felon driving with a suspended license, 22 SC 180437, theft by receiving stolen property, conviction 2017 for possession of tools. Nothing further.
All right. Go ahead, Ms. Rondon.
All right, Mr. Watley is 30 years old and is from Atlanta. He has two kids, age 7 and 8. He was working for the City of Atlanta Waste Management. All of his family lives in Atlanta and he has a great support system surrounding him. He would be willing to wear an ankle monitor, and when he would make bond, he would live at 1028-3 Richfield Court, Jonesboro, Georgia 30238. And we are asking this court to set bond in the amount of $20,000.
Is he going to have his same job with the City of Atlanta? Because I think that, is that Fulton County, that address in Riverdale? Or is it Clayton? Sir, is it Clayton County? Give me a thumbs up or a thumbs down. Where you live?
It's Clayton County.
Clayton County, okay. So is he going to get his, are you getting your job back with the city?
I pray and hope I can get it back.
All right. What says the state?
Your Honor, good afternoon. This is ADA Amjadi on behalf of the state. The defendant does have a pretty extensive criminal history. I do have serious concerns about the fact that he had a firearm in this case. I would respectfully request something not too different from what Ms. Rondon did. Perhaps a $20,000 bond for the charge of possession of a firearm by a convicted felon, and then $1,000 for the other charges accompanying it, for a total of a $22,000 good bond. I would also respectfully request, Your Honor, that the defendant have no firearms, weapons, or replicas of weapons during the course of his pretrial release or as a term of condition of his bond. And additionally, Your Honor, I would respectfully request an ankle monitor. I have no objection to it being paid for by the county.
Okay, so Ms. Rondon, just, I don't know if you've checked, but on Odyssey, there seems to be a DeKalb County probation warrant, I think, or DeKalb County hold. Not sure how up to date that is, if it's good or if it's not good anymore, but I just want you to know that it shows up on Odyssey. Just for your edification, it says DeKalb County. It's a 10 CR case. Would you like the number?
Yes, please.
10 CR 3463.
Thank you.
Okay. So I'll do no drugs unless prescribed, no alcohol, no weapons, no driving until you get a valid license and a valid tag. Out of Fulton County, unless you're here for court, lawyer, or if you get your job back with the city of Atlanta, you can come for work only. But you're going to have an ankle monitor with a 24-hour curfew, except for court, lawyer, and work and medical. You have to supply the name of your employer, proof of employment, and your schedule. So if you get back to work with the city of Atlanta, sir, you can come back into the city and into the county to do your work. But besides that, you're going to have to stay out of Fulton County. You have to let your lawyer know, show her proof of employment and your schedule, and then they'll also have to be given to the state. Okay?
Yes, ma'am.
I do 15, 4, and 1. 15,000, 4,000, and 1,000. Best of luck to you, sir.
Is that a good bond?
Yes, sir.
Thank you.
Yes, sir. All right, let's see who else we got in there. St. Louis. There's another one we got a question on, right?
Yes. Well, no, that's a conflict case, Judge.
Okay. Pull the piece of paper back up here with St. Louis. All right, Stanley St. Louis. Stanley St. Louis, can you, okay, see you there. I'm sorry. Ms. Rondon, are you going to handle this one also?
I don't believe this is ours.
All right.
I
so-
have it closed on our end.
All right. Who's here from conflict? Anybody?
All right, that's me from conflict.
Okay.
Any chance we can circle back from this and I can double check?
Okay. Give me, it's position 20, 21 CP 200623.
All right, I'm gonna figure it out. If we could come back to him, please.
All right. Well, we got one more for you, Jonathan. So hold on, Mr. St. Louis. Jonathan Briscoe. Thank you, sir. 22 CP 208308, 241 days without indictment. As of April the 22nd, 2022, there is a $50,000 good bond. Possession of cocaine with intent to distribute, willful obstruction misdemeanor, entering an auto with intent to commit a theft or a felony. That's 1, 2, 3, 4, 5, 6. Eight counts of entering auto, the intent to commit a theft or a felony therein, and 1 count of forgery in the first degree. Raw.
Judge, you said Jonathan Briscoe?
Yes, ma'am.
Only prior arrest, nothing further.
All right. Go ahead, Ms. Rondon.
All right, Mr. Briscoe is 19 years old. He's lived in Georgia his whole life and the majority of his family lives here. Upon release, he would live at 6893 Justin Drive in Loganville, Georgia, 30052 with his grandmother, Miss Priscilla Cooper. He has 1 kid. It's a girl who's 2 years old. He did complete the 11th grade and is very interested in joining a GED program in order to complete his education.
All right. What says Ms. Jotty?
Your Honor, the state's position here is that bond as previously set, the $50,000 good bond, is fair and reasonable given the extent of the offenses.
All right.
Oh, I apologize. We're asking for a reduction in bond, please, as Mr. Briscoe cannot afford $50,000.
All right. So I want you to see the attached bond order, Miss Jamie. No drugs unless prescribed, no alcohol, no weapons, no further contact with your co-defendants. Lameka, Lameka, President, Cameron Jones, and Noel Williams. Those are all co-defendants. No further contact with Jason Rabinowitz, Rabinowitz, Eric, ERIKVANNAME, David Spinato, SPINNATO, Aisha, AISHA Phillips, James Llewellyn, LLEWELLYN, and the last victim is SOHALB CHODHRY. So you're going to stay out of Fulton County unless you hear from court or to see your lawyer. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical. Is he going to have a job, Ms. Rhonda?
That is to be determined.
Give me put in exception for employment.
Yes, please.
Okay. And sir, you can get an exception for employment. You have to provide proof of employment, the name of your employer, where you'll be working in a schedule. You have to supply that to your lawyer and the ankle monitoring company who will then supply it to the state. Also, you have to stay away from all public drugstore location. And the only reason you're going to come back to Fulton County, sir, is to see your lawyer or go to court. Don't get gas in Fulton County. Don't do anything in Fulton County. Fill up with gas where you live. Get on 285. Go wherever you need to go except Fulton County. Don't fill up with gas. Don't get a flat tire. None of that. So I'm going to do 7,500. And sorry, Ms. Jamie, I didn't even print what this one says released on original bond from count 2. Let me see. I probably printed them both. I tell you, for each entering auto, that's count 3, 4, 5, 6, 7, 8, 9, and 10. I'll reduce those to 3,000 each. Forgery in the first degree, I'll reduce that to 2,000. Count 1, 6,000. And let's see, let me find out what count 2 was. Sorry, Ms. Rhonda, it's pulling up a little bit slower. All of them say release on original. All right, 2,000, 6,000, 2,000, 3,000 per count, all the way 1 through 10, and then 2,000 on number 11. Best of luck to you, sir. You can lay the vote. Stat of Fulton County. All right, you want us to go to South Annex and get that while you check on St. Louis, Ms. Rhonda?
Sure, yes.
Okay. Who do we got down there, South Annex?
We have before you position number 12, Ms. Jackson.
All right.
Ms. Rains was released on 12/8.
Gotcha. And all right, this is 22 CP 212544. Shantina Arlena Jackson, 84 days without indictment. We've got aggravated assault, vehicle into person, criminal damage to property, second degree, cruelty to children in the first. No bond as of 9/23.
Your Honor, I apologize, but if I may speak out of turn, I was told that this case was indicted, I think at the end of last week.
Let's see.
Judge, we can go to the next one. I'll look on the list.
Well,
Okay.
if I can just comment, Judge, Attorney David West for Ms. Jackson. They may want to double check because there were 2 cases pending. Both were similar charges. One of those has been indicted. It is 22 SC 185122, but that is not, I don't believe that's this case. So
Yeah, it's not this case, Ms. Anjadi. Let's see.
Yeah, that's a separate case that's open, Ms. Anjadi. So
The
is that what you're thinking of?
212544 case?
No, that's a different number.
Yeah, the one that's indicted, incident date was 9/2/2022, and this one is actually, but it's different. Yeah, it's aggravated assault. It's same date but different charges. So on the other indictment, let's see, let me check. Was there supposed to be 3, 4, 5 counts of aggravated assault, Ms. Johnny? Was the other ones just added?
Yes,
mean-
Your Honor. And
Alright,
these are the ones that come up when I type in the 22 CP number that corresponds to position 12 on this evening's
Alright.
calendar. It looks like it was indicted on November 18th.
I'm gonna pull up the indictment, Mr. West. Let me look at it real quick.
Right. If you look at it, Judge, you'll see it has a different incident date than the CP number we're here on today. And the other thing that is interesting is if you look at the case information section under disposition events, it notes counts 5 and 6 were not presented to the grand jury. Those appear to be 2 of the charges in the CP case we're on here. So it almost looks like the state went to indict both cases together and chose not to present part of this CP case. But your guess is as good as mine. All I know is this CP case does not show as indicted.
Right, and Ms. Johnny, the 2 on the charge history, it just says it doesn't have this case. It references 22 CP 212502.
Correct.
And it arrest charges and then prosecute charges. It doesn't address this one at all. It has no bond. What would you like to do? And this is the last night for private attorneys until first of the year.
Right. So she would pass through the 90-day threshold if we don't deal with it now.
Sorry, Your Honor.
On the Odyssey, it's
Confused
showing
by
us
what's
2
going
separate
on.
open cases.
Ooh, what, Bostic?
Under Odyssey, under a list of her cases, it's showing as 2 separate open cases. This case and the SC case, they're showing as 2 separate open cases.
Correct.
Yeah.
Like under case management, Jada, if you put her booking number, it'll give you a list of all of her cases.
Yes.
And if you see all her cases, it'll show in blue, and blue means open. And so both of these are still open. The CP case, 22 CP 125,
Yeah, that one's still open.
and then the 22 SC 185122.
Right. And this case is from an April incident, and the indicted case is from a September incident.
All of the charges I have on the 22 SC case list a September 2nd, 2022 court
It
date.
sure does, sir. Both of them have the same date.
Yeah.
One is a vehicle. Let me see what the indicted case is.
I will pull up the indictment really briefly, and I apologize, Mr. West, for all of this confusion. This is
No,
a
it's-
special unit case, and the special unit
Ms.
sent me an
Anjati, when you
announcement.
pull up the case, it says companion case under the indictment.
Okay.
Yeah.
It
If you
has
look
the
at
CP number listed.
Y'all got to talk one at a time for the court reporter. So
if you look at the indictment, it'll say the all 4 counts, even though the charges appear similar, all 4 counts are from a September incident date. And the 22 CP 212544 case has an incident date of 4/25/22. So it is not part of that indicted case.
So it actually lists a September date within the state system, Mr.
Right.
West, for those
Yeah, if you-
charges, for the
if you pull
22
up-
CP.
if you pull up the warrants, the date on there is April 25th. The X on the physical warrants.
Okay.
Between 8 p.m. and 8:38 p.m. Do you have that indictment pulled up? Because this is Brianna Ladson is an alleged victim in this one.
I'm trying to pull it up right now, Your Honor.
Let me see. Yeah, these are all September dates on the indictment. And it's got Miss Ladson. steering a motor vehicle.
Sladson is listed here as well.
Jameson, Shoulder, Sounders.
Count 4 is Miss Ladson.
You got somebody from your office that can do a little research on it while we keep going?
I'll ask someone, Your Honor. Thank you.
Okay, I can
And
hold
I
off.
apologize for.
No, that's okay. That's all right.
I can look into it, Miss Amjadi, if you want to send me
Thank you
this.
so much, Ms. Patel. I
No
really
problem.
appreciate it.
Thank you, Ms. Patel. All right, let's see. Ms. Rhonda, what'd you find out about Stanley St. Louis?
He is in fact ours. I'll be ready to go for him
Okay.
in a few minutes,
Oh, in a few minutes? Okay,
if that's possible.
sure.
Yes, sir.
All right, what about Tanisha South Annex? Do we got Tanisha Linton?
Checking, Your Honor.
Just real quick, it appears she drove at them both. She drove at one, and when the other one was going to get the child, she drove at the other person. So that's why it's two separate, it's on the same date, but two different cases. That's why they probably was trying to indict it together, because it was kind of the same incident. But that's why it's two different cases. One is Ms. Louder and one is Ms. Souder, Soudr.
South Annex, you got Tanisha Linton?
I'm going to get her, Your Honor.
Okay, let's see. Let's grab somebody. How about Tyler Thornton? Wave your hand, Mr. Thornton, if you're here. Tyler Thornton? No? What about Justin Hayes? All right, there's Mr. Hayes. We have William. Yes.
Was mine, Judge. He's not, they didn't have him up, Tyler Thornton. That's my case.
Hold on. Are you representing Justin Hayes?
No, Tyler Thornton.
I am, Your Honor.
Well, look, okay, everybody, here you go, one time. The jail has one person pulling people. Be cool, everybody, just be cool. If they're not in the booth, I have to go to the next case, okay? Unless you
Understood.
guys want to go to the jail and pull people, then y'all can help out. So, Justin Hayes, Mr. Moran, are you here?
Yes, I am, Your Honor.
All right, good. Now we're cooking with some gas. 22 CP 213243. Justin Hayes, 59 days without indictment. Aggravated assault, cruelty to children in the third degree. No bond as of October 17th. Rob.
Number is Hayes.
24.
Petition 24.
24. Okay. Two prior arrests, Judge. Last arrest was 1994. I was born.
Barely.
I barely was too, Your Honor.
No. I was good and born. I was out of high school.
Yes,
Go
Your
ahead,
Honor,
Mr.
that was going to be one of the first things I was going to say, that it's been over 25 years since Mr. Hayes' last criminal incident. The alleged victim in this case is the ex-wife of his girlfriend. Mr. Hayes and his girlfriend, I won't go into the facts too much, but he has very limited criminal history, no felony convictions, I don't believe. He lives at 55 County Roads Circle, which is where he'd be staying if he's released on bond. Again, that's 55 County Roads Circle in Stockbridge, Georgia. Zip code is 30281. Mr. Hayes, I would say that he does not present a significant risk of fleeing the jurisdiction. He's never had any fleeing or eluding charges, and as far as I know, has never had any FTAs. Again, I don't believe he poses any significant risk of committing any additional felonies if he's released or injuring people or the community. Again, this goes back to his lack of significant criminal history and over 25 years without any charges. The facts in this case are kind of important. He's not guilty of these charges, Your Honor. He was making dinner with his girlfriend and the girlfriend's ex-husband forced his way into the home, and then alleged that Mr. Hayes pulled a gun on him. Mr. Hayes and the girlfriend, Tasha Romeo, have said that's not the case. That's not what happened, that no gun was pulled. Mr. Hayes has been a MARTA employee for the past 15 years, and he does still have his job being held open. He has 4 children, most of whom live in Georgia. Between the ages of 17 and 25, they are adult children. He's got 2 aunts, an uncle, and a cousin, significant family contacts in the community. Like you said, he's been in custody since October 15th. That would be 59 days. So he's not hit the 90-day mark. But based on his lack of criminal history and what I would pose as the falsity of these charges, I do believe that he should be given a bond. I would be asking for a signature bond in this case, Your Honor, and if not, one hopefully not to exceed $10,000.
All right, Ms. Amjadi.
Your Honor, there was a forensic interview done with the minor child who was the victim of the cruelty to children charge. And the results of that forensic interview, he did give a statement that seemed to be consistent with indicia of reliability, that the facts did involve the defendant pointing a gun at the child's father. Your Honor, the court has previously noted that there was a danger of harassment and intimidation to the victims, in addition to a general danger to the community. The state concurs with that position, and we would say that because the defendant is not legally entitled to bond at this time, that the defendant should remain in no bond status.
May I respond, Your Honor?
Yes.
It's the allegation of the girlfriend, Ms. Tasha Romeo, that her son was coached by the ex-husband. They are in the midst of an ongoing custody battle right now. And she has told me multiple times that the ex-husband has basically filed these charges as a way to gain leverage in that custody battle. And in addition, as far as any risk to intimidate witnesses, Mr. Hayes never had any contact at all with the alleged victim, Mr. Romeo, before this actual incident date where Mr. Romeo forced his way into Ms. Romeo's home. Mr. Romeo was not arrested for these charges. But Mr. Hayes never had any contact with the alleged victim before the incident date and has not had any contact since then. So I would say that he's not in any way a list to intimidate witnesses.
I got you, but he's only been in 59 days.
That's correct. He is not legally entitled to bond, but he is eligible for one. And I believe that that's to be left at the court's discretion. And based on his lack of criminal history, his lack of any previous violent convictions, the fact that he was simply cooking dinner with his girlfriend at the time that the alleged victim forced his way into the home, I would say that I would ask you to please use your discretion to grant him a bond in this case. I think he is deserving of one.
Well, I'm sure y'all call the news or something. Go ahead, Ms. Belmjotti.
There was one thing I forgot to tell you, Your Honor, and I apologize, that the victim did state that he was in fear for his life and that of his sons. I'm not sure if I indicated that earlier, but I did want to put it on the record.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Jamell Romeo, Romel. You got an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical work. You have to supply the name of your employer, schedule, and the location you'll be working, sir. No further contact with Kingston Romeo, Romeo. No further contact with Tasha, Tasha Romeo, Romeo.
Your Honor, if I may, I apologize for interjecting here. Tasha Romeo is not a victim in this case. This is Mr. Hayes's girlfriend. She has completely confirmed everything that Mr. Hayes has said. She does not.
He can't be around the kid. So I don't know how he's going to work that out, but he can't be around the child.
All right.
Jamell and Kingston Romeo, Your Honor. Those were the listed victims.
Okay, Jamell and Kingston Romeo. So it's a him problem to figure out how he's going to see his girlfriend. Stay away from 680 Murphy Drive, and stay away from. Is this where his girlfriend lives? 2727 East Point Street.
I believe so. Mr. Hayes' address is the 55 County Road Circle address that I gave you earlier. So that's where he'll be staying.
All right, well, she'll have to go see him because he's going to have to stay away from the incident. Okay, it's 2568 Harris Street in East Point and 2727 East Point. Stay out of Fulton County unless you're here for court or see your lawyer. You said he still works for MARTA?
Yes, that's correct, Your Honor.
All right,
He's worked for 15 years.
he can come here for work, but he has to supply his schedule, the location he'll be working. He has to supply it to you and to the state.
Thank you, Your Honor.
Hold on, 10,000 on count 2, count 1, 50,000. Best of luck to you, sir.
So that would be a 70,000 aggregate bond.
No,
Your
that
Honor?
would be 50 and 10. That's 60.
60,000 total.
Yes, sir.
Thank you, Your Honor.
Thank you. Are we ready back on?
I have Miss Linton before you, Your Honor.
All right, Miss Linton. Now let me grab her paper. All right, let's see. Here we go. Tanisha Charney, Charney Linton, 22 CP 212793, 74 days without indictment, got 2 counts of cruelty in the second degree. Wow, there's a 25,000 bond.
No prior arrests.
All right, go ahead, Ms. Rondon.
All right. Miss Linton is 23 years old and is from Atlanta. As stated, she has no prior criminal record and she has no history of failing to appear for any required court dates. We are asking for a reasonable reduction in Miss Linton's bond amount as she is indigent and cannot afford the $25,000. We are also asking for bond conditions to be modified. We would respectfully ask the court to allow Miss Linton to visit her daughter while her daughter is in the hospital and to be able to continue with visitations once her daughter is released.
Is there a defects case open?
Not that I am aware of.
Ms. Amjadi.
Your Honor, I'm appearing on behalf of the Crimes Against Children Unit. They have sent me their announcement. Your Honor, to begin with, there is no basis for further modification presented in the motion. Additionally, some aggravating factors against modification of the bond amount would be that the defendant lied about what happened to law enforcement. She initially tried to blame her 4-year-old niece for shaking the baby. This explanation was not consistent with the medical evidence. The 2-month-old victim had multiple skull fractures and multiple hematomas, so many that the healthcare staff at the Children's Hospital could not count just how many skull fractures and hematomas there were. The CHOA professionals repeatedly asked the parents at the time whether the child had any injuries or accidents, and then she came up with a story about falling near a refrigerator with the child. Oh, I'm sorry. This was the co-defendant who came up with a story about falling near a refrigerator. Let's see. But the defendant here today before the court, Your Honor, she was more concerned about covering for the co-defendant, who was her romantic partner, than she was about getting treatment for her child and reporting any injuries or accidents with the baby. Let me see. Your Honor, the state also requests that the mother, Miss Linton, should have no contact with the child. And I believe there may be a defects action, Your Honor, but I'm not totally sure.
Okay. All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with KALONIGAMMON unless it goes through defects. So if juvenile court orders something, then she can visit to comply with a juvenile court order. Until then, ma'am, no ma'am. Okay, unless it's ordered through juvenile court, then you can visit with the child to go through that. No further contact with your co-defendant, Isaiah GAYMON. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical. Does she have a job? Do you want to go to, Ms. Rhonda?
Not that I am aware of.
All right, court, lawyer, medical. Do you work, ma'am? Okay, and also anything, Ms. Jamie, anything dealing with juvenile court, anything she has to comply with for defects, she can leave there. Ma'am, you have to tell the ankle monitoring company and your lawyer so that he or she, whoever it's going to be, Ms. Rhonda, whoever it's going to be, tells the state. And she going to live in Fulton County still? Did you say no?
No.
Okay. All right. You stay out of Fulton County unless you're for court or to see your lawyer. Is your child in the hospital in Fulton County?
No.
Is that no?
No, she's in Detroit.
Okay. So stay out of Fulton County unless you're for court or to see your lawyer. Stay away from that child, ma'am, unless juvenile court orders it. I modified a little bit of it, so I'm going to reduce it from 25,000. A previous judge set this on the 17th, so I have to modify it a little bit. So 24 and 24. Best of luck to you, ma'am. Is that everything, South Annex?
No, Your Honor, are we finished with position 12? Ms. Linton, have a seat over here.
That one is Jackson. Mr. Jackson, did we figure that out? What we're going to do with that? Anybody? Mr. West? Ms. Amjadi, did figure anything out?
I'm conferring with Ms.
No.
Mattel, Your Honor.
Yes, Your Honor. They are two separate incidents, although they are the same victims. One is from April of 22. And I see that one's from the August of, I think one's from September of 22.
Right.
We're just trying to figure out the documentation on our side looks like it's different from your side. So I just need to confer with Ms. Amjadi for one moment. We're messaging each other.
Okay.
And I apologize, Your Honor, for any inconvenience this causes, but the paperwork is very confusing in our system.
No, yes, absolutely. And it's always issues with these private lawyers. The public defenders just smooth as they can be. The private lawyers always cause me some problems. So we'll move to the next one until then, okay? What
It's
about?
not like I'm not Daniel Kane, Judge.
I know, I see him. I was putting his on the bottom. No, I haven't gotten yours yet, Mr. Payne. All right, what I got?
I hope you're kidding about being on the bottom.
Yeah, Mr. Lieutenant McDaniel sends me the order he wants it to go in, so I have to go in his order. David Chase. David Chase, are you in a booth?
Judge, I'm here for him. I don't see him in the booths.
All right, wave your hand if you're David Chase. Not David Chase. Okay, let's see. What about last name? Oh gosh, Biteye. There we go. Real hard to see in 3 South. Says Sarah Becker.
I'm sorry, Your Honor. I was distracted. Did you say Ibrahim Bidai?
What's his last name?
Bidai?
That's exactly what I said.
I apologize, Your Honor. I'm multitasking, so I want to apologize. I work with Ms. Becker. I'm Meg Strickler.
Okay, yep. 22 CP 212368. 89 days without indictment. Got forgery in the 3rd degree, abuse, neglect, exploitation of a disabled or elderly person. 89 days without indictment. No bond as of September the 16th. Pre-trial.
Judge Mr. Bidai. One prior arrest that equal to a bunch of open cases. 20 CP 191804, theft by taking 2 counts, financial ID fraud 3 counts. 20 CP 191805, forgery in the 3rd, financial transaction card theft, financial transaction card fraud. 22 CP 212368, forgery in the 3rd. That's this case.
Yep.
22 CP 22 CR 004614F, theft by taking. Thank you.
Bostic, we got two tomorrow night and Thursday night, and then you're off for a couple of weeks. Well, at least at night.
I quit now. My tongue has retired.
Go ahead, Ms. Strickland.
Hi. Yeah, basically, this is a kind of convoluted story, Your Honor, and all of the actions, for the most part, all stem from the one incident. And if I could try to explain it, I will. In April of 2020, the police see my client allegedly open a mailbox and run. And so that was the first one you just heard, that formally accused case. Okay, so that's April 5th. Okay, when they arrest him, they get in his phone. All right, and in the phone is information, and that leads to your 20 CP 191804 and 20 CP 19805. So those cases are all kind of together, all right? And then the case that we're here that I filed a motion to set bond is the one that one might argue might have come from that same case. We don't know yet because I'm not the prosecutor and I don't know. Now, to talk about the Yale factors, Mr. Bideye is only 24 years old. He was a student at Georgia State. He's obviously not been able to attend classes. While he was in Fulton Rice Street, there is a significant circumstance that occurred. He was stabbed, had to get surgery. He's back out among general population again, but he was in Grady for at least 5 days. Again, I don't have all the specifics, but Mr. Prosecutor may. He has a strong upstanding character, except for all the things we just mentioned. His brother, his 3 little brothers, his girlfriend, his mom, and his 1-year-old son all live here in the Atlanta metro area. And he has a job waiting for him once he gets out. So, Your Honor, I'm asking for you to set a bond for these 2 charges, something like $10,000 each. And, he'd be willing to wear an ankle monitor.
Is he still going to live in the Lithonia address?
Yep, that 20, I wrote it down.
Yeah, the one on the booking sheet, I think so.
2230 Greenbrier Way.
Miss Somjadi.
Your Honor, the state is requesting, given that the defendant is now legally entitled to a bond, that the court issue no lower than a $50,000 cash bond. It appears that Mr. Bideye is the ringleader in a mail theft group. It looks like a federal agency is considering taking this case due to the increased prevalence of mailbox theft since the summer. But essentially, Your Honor, there's an extensive history here, and the defendant does pose a very, very high risk of reoffending. This appears to be sort of his modus operandi, Your Honor, to go to one of the mailboxes and to take envelopes out and to take checks out. For that reason, Your Honor, we feel that a $50,000 cash bond is appropriate in this situation.
All right. Check in. I usually just see how many of his cases it is. Ms. Strickler, does all of his other cases have bonds?
Yeah, the 20 CP 19805 has a 15,000 straight bond, and then the 20, I apologize, CP 191804 has a 20K bond, straight bond, which he's posted.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay out of Fulton County, sir, unless you're here for court or to see your lawyer. Don't get gas. Don't get anything to eat. Stay out of Fulton County. 285 will take you anywhere you need to go. Don't run out of gas on 285 when it hits Fulton County. That is a violation of my bond condition. And that ankle monitor with the 24-hour curfew, except for court, lawyer, medical, does he actually work?
Yes, he has a business, Your Honor. It's a family business that's dealing with trucking. So I wrote down the transportation company. So I can supply that information if you need to. It's called Bideye Transportation.
All right. So he's got to submit proof of employment, a schedule, the exact location he'll be working. And besides that, he's got to stay home. Stay away from 325 Shady River Terrace. No further contact with Maria, ACETO. Make sure I got everything. All right.
And Your Honor, is that going to be what the Madam Prosecutor suggested, the 50,000 straight cash bond only? Or can he use bondsman?
Let's see. I want to do, you wanted 25 and 25, right, Ms. Somjadi?
Yes, please, Your Honor.
We're going to make count 125, count 250. We'll make that a $75,000 good bond. Best of luck to you, sir. They may revoke your bond on the other ones since we got this other one. I don't know. Ms. Strickler, you may know if you can all work out the dates. Best of luck to you. Is that all you got, Ms. Strickler?
It is, Your Honor. May I be excused?
Yes, ma'am. Have a good holiday.
Thank you. You too.
All right. Do we got anything on South Annex case yet? or Mr. St. Louis?
We can come back to Mr. St. Louis.
St. Louis? So go with St. Louis now, right? Two one CP 2000623 Stanley St. Louis. Like 111 days without indictment. There is a $5,000 split bond. Pre-trial. Did y'all come off of that bond
I reckon so.
as of August the 31st? Pre-trial.
Judge, we would have come off the bond because he was rearrested, got a new case, 22 CP 211762, Schedule 1 or 2 substance and a misdemeanor possession, nothing further.
So, Ms. Rhonda, did he already make post bond on one count and we just need to address the two pretrial cases?
I believe so. I'll have to double check.
I'll look. Go ahead with your argument. I'll look while you're doing that.
Okay. Mr. St. Louis is 25 years old. The last address I know of where he would reside once he posts bond is 729 Cooper Street, Atlanta, Georgia, 30315. He does have no prior criminal history and he does not have any record of failing to appear to required court dates. Based on that, Mr. St. Louis is not a flight risk, nor is he a danger to the community. We would be asking for bond to be set in the other charges.
All right. Ms. Jody.
Your Honor,
And pretrial did come off his bond on August the 31st.
thank you, Your Honor. We would respectfully request that the prior, that for the charge of possession of a firearm during commission of a felony, the court issue a bond in the amount of $15,000. And with respect to the other charges, a bond amount of $5,000 each.
Right. No drugs unless prescribed, no alcohol, no weapons. So look here. Doesn't look like he's made this bond. Wait. Yes, he did. He's already posted that bond through a security for possession of a firearm during the commission of a felony. So I'm just addressing possession of marijuana with intent to distribute and possession of MDMA. And what did you say your numbers were on that?
5,000 for each, Your Honor.
All right. So count one will stay at 5,000 where it was previously set. Count two, 5,000. Count three, 5,000. No drugs unless prescribed. No alcohol. No weapons. Stay away from 732 Cooper Street Southwest. No further contact with your co-defendant, Devante, DEVANATE POSTELL. Best of luck to you, sir. Thank you. Now we're ready.
I'm
Yes,
sorry, I
ma'am.
have a quick question. So the attorney, so is it stay away from 732 Cooper, but his mailing address is 729 Cooper?
Right. It's just down the street, so we can stay away from that one.
Okay.
All right. So are we ready for Miss Jackson?
I'm ready.
That was good, right, Mr. West?
It was.
Miss Amjadi, are you ready for Miss Jackson?
I believe so, Your Honor.
Okay.
If I can only find the position on the calendar.
It's
12,
position.
okay.
Yep. 22 CP 212-544, 84 days without indictment, aggravated assault, vehicle into person, criminal damage to property, second degree, cruelty to children in the first degree. No bond as of September the 23rd. Wow.
Who was she again?
Shatina Jackson.
Oh, there she is. Shatina, 18 prior arrests. The other open case for aggravated assault, 3 counts, criminal damage, cruelty in the first, sounding the Judge Edwards, 1 FTA, 6 misdemeanor convictions, nothing further.
All right. Go ahead, Mr. West.
Yes, Judge, 31 years of age. She was working at Finn and Southern. She's a resident of College Park, family in the area. She's also going to cosmetology school. I am retained. I will be assisting her with these cases. On the other case, I don't know why the case since April hasn't been indicted in all this time, and the case from September has. I'd like 5, 5, and 10. 5 on cruelty, 5 on criminal damage, and 10 on ag assault.
And I
Please,
think on that 22 SC, it's in no bond status. Am I right, Mr. West?
currently, we have a bond hearing set in that case.
Okay. Ms. Amjadi.
Your Honor, will consent to that bond amount.
Just can I
Pending
interject
resolution.
just a second? I don't appreciate Mr. West talking like me when he was talking in the beginning, stressing his words.
What?
You want 5 on each, Ms. Amjadi?
Yes, please, Your Honor.
All right, 5 on each count. No drugs unless prescribed, no alcohol, no weapons, no further contact with BIONNA Ladson, LADSON. No further contact with their minor child, initials AS. Stay away from 445 Markham Street. No further contact with Hennessy Head, HEAD. You can have ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. She still gonna live on Camp Creek, Mr. West?
That's what I've got. LO2.
All right, you still gonna live on Camp Creek, right, ma'am? Give me a thumbs up. Thumbs up. All right. And you can also leave for employment as long as you supply the name of your employer, proof of employment, the location you'll be working, and a schedule. Ma'am, you have to supply that with the ankle monitoring company and to Mr. West so he can supply it to the state. Best of luck to you, ma'am. Thank you, South Annex.
Thank you. Is that 15,000, Your Honor?
Yes, ma'am.
Thank you. Have a
Thank
good
you,
evening.
Judge.
Bye.
Thank you. All right. David Chase. Oh, David Chase. Keep going now. Or Thenius Martin. There we go. Hope I pronounced it right, sir. I apologize if I didn't. Position 12, Bostic 22 CP 212631. 81 days without indictment. Obscured missing license plate, possession of firearm by a convicted felon, possession of a firearm or a knife during the commission or attempt to commit certain felonies, purchase, possession, manufacture, distribution, sale of marijuana, possession of MDMA with intent to distribute, possession of a controlled substance in Schedule 1 or 2 with intent to distribute. No bond as of September the 26th. Rob.
Judge, in regards to Mr. Martin, 30 prior arrests, currently on probation for aggravated assault with a deadly weapon, criminal damage to property, firearm during, firearm by, 18 SC 156926, sentence January of 2019, 4 months confinement, 9 years, 8 months probation. 2 FTAs, 2014, 2018, 1 arrest for probation violations. Other convictions is for ag assault and for drugs, nothing further.
All right, go ahead,
Good
Mr.
evening.
Lamar.
Good evening, Judge Muhammad Luwamba on behalf of Orinthius Martin. Fortuitous turn of events actually got Mr. Martin in this situation, Judge, and we look forward to getting the discovery so we can take the lab results to his doctor so we can show that these medications were prescribed. If you didn't see when Mr. Martin walked in, Judge, he walked in on a cane. That's because a couple years ago, he was shotgunned as a victim in a carjacking. He was shot in the side and in the leg. The woman that he was with was shotgunned in the chest, and she was actually killed in that carjacking, a victim right here in Atlanta, Georgia. Since that time, he has been heavily medicated because of his pain. We want to, once we get the lab results back and once he gets out, because the doctor won't release that information to me, we can get all his prescriptions that he's been prescribed to show that he was lawfully in possession of the narcotics or the prescription medications that were found in the car. He also, in regards to the firearm, I haven't seen any evidence of that, but he's also, since that shooting, been involved in very, very deep counseling that Grady recommended for him, because after that, he was in the hospital for several months. They thought he was going to die, and he's still seeking that counseling. He was still in counseling prior to him being arrested for this particular event, Judge. Unfortunately, the jail does not have the capacity to handle his medical needs. He is not getting the painkillers that he needs in order to address his pain. We believe that because of his physical condition and because him being in jail for 66 days without indictment, he is deserving of a bond. He's not a threat to any witnesses. there aren't any witnesses to threaten in this particular case. He's not a flight risk. He's been residing in the state of Georgia, a city of Atlanta, for the bulk of his life. He will return to court, despite the fact that he has a felony history, Judge, despite the fact that he's been a gunshot victim of the rising crime in Atlanta, and despite the fact that the woman that was with him was murdered. He has a very thriving Airbnb business. He owns 6 Airbnbs, and he has 3 cars on Turo. So this is someone that, despite the hardships in his life, despite being shot and having some problems previously that we acknowledge, has been trying to turn his life around. That, in addition to the fact that we don't believe Fulton County Jail has the capacity to handle his medical needs at this time. I come see him almost every week. He's in a lot of pain. We're just asking that the court grant him a reasonable bond. We are fine with the ankle monitor or whatever restrictions that the court would like to put on him. I've already spoken to his current girlfriend. She's willing to manage the Airbnbs, so he doesn't have to, go around, check on the properties, and go make sure that they're not destroying his properties and whatnot. The Turo business doesn't require him to leave the house. People just go pick up the cars and they cash at him they pay him through the Turo app. He doesn't even have to meet these people, and his girlfriend can also manage that, Judge. So based on the aforementioned factors, we're asking that the court grant him a reasonable bond. Excuse me.
Okay, just so you know, so it was 59.6 grams of ecstasy, 10.5 grams of morphine, 5 oxycodone pills, and 60 grams of raw marijuana. Miss Samjadi.
Your Honor, given the defendant's very extensive criminal history, he has 29 arrest cycles with convictions for drug offenses from the mid-90s. In the early 2000s, he began acquiring quite a bit of violent convictions. There was, in 2001, an aggravated assault with intent to, I think, opposing counsel would waive sounding. 2005, there was a conviction for armed robbery, as well as one for aggravated assault with a deadly weapon. In addition to the case for which he's currently on probation in 2019, which was aggravated assault with a deadly weapon, damage to property, and possession of a firearm during commission of a felony and by a convicted felon. The defendant's history is very troublesome, Your Honor. It shows that he presents a significant likelihood of reoffending and that he's a danger to persons and property in the community. For that reason, Your Honor, given that the defendant is not yet at the point where he's legally entitled to a bond, the state would respectfully request that his case remain in no bond status.
All right. Well, he wouldn't be back on it to the first of the year, but like I said, somebody will complain. Sure, but because we're not going to be back with the private attorneys until sometime in January. Obscured license plate, $200. Possession of a firearm by a convicted felon, $15,000. Possession of firearm during the commission of felonies, $15,000. Let's see. Possession of marijuana, 10. Possession of MDMA, 10. And Schedule 1 or 2, 10. $200. $15,000, $15,000, 10, 10, and 10. No drugs unless prescribed, no alcohol, no weapons. Stay away from 439 Highland Avenue. You have ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical, work, as long as you supply where you're going and the schedule to the ankle monitoring company and to your lawyer. Where does he live?
Mr. Martin, you can say your address.
No, he's muted. Center Street.
Oh.
Center Street. Okay. So that honor will be paid for by the county's employer. Name of it or where he works for himself. He has to have a schedule where he'll be going, the exact location. You need to get it beforehand. Best of luck to you, sir.
Judge, can you give me that total bond amount? I'm sorry.
I didn't total it up. I didn't total it up. Write the number down.
200. Your Honor, I believe that was 60,200.
Okay, thank you.
Thank you. Brendan Milam. All right, there he is. We got Eric, who's Brendan Milam's lawyer here. We got a lawyer for Brendan Milam. Do we have a lawyer for Brandon Milam? On here it says Eric Johnson. Hold on, sir. How about we got Kevon Asbury.
Yes, Your Honor, that's another case of mine.
All right, 21 CP 202-112 Kavan Asbury. It's 88 days without indictment, possession of tools for the commission of a crime, entering auto, giving false information, law enforcement officer, theft by taking, and possession of marijuana less than an ounce. This was on pretrial. Looks like they came off of it. Wrong.
Judge came off of it because of new arrest, 22 CP 212353, firearm during marijuana with intent, Schedule 1, Schedule 2, Schedule 4, drug-related objects, nothing further.
All right, go ahead, Ms. Moran.
Thank you, Your Honor. Mr. Asbury, Kavan is 18 years old. He's got no prior criminal convictions, and it's what you stated earlier and what pretrial stated is correct, that he was initially arrested back on August 10th, I believe. Oh, yeah, August 10th of 2021, about a year ago, a little over a year. He spent 3 days in custody. He was released on August 12th. And then when he was rearrested on this new charge, since then he has spent an additional 88 days in custody. So my first argument here, Your Honor, would be that he has spent a total of 91 days in custody, and the case is still currently unindicted. With that being said, Mr. Asbury is, as I said, he's 18 years old, no convictions. He is enrolled in what's called the Youth Build program, where he is attempting to get his GED. He's also employed, and again, this is 18-year-old, employed at Royal Roots Barber Shop. I won't go too into depth in the facts of the new case, but those are drug charges, and there's a co-defendant. He moved out of his parents' house maybe a month or two before this most recent incident and moved in with someone, which was apparently a bad choice because that other person, his roommate, was apparently up to no good. But I will say that I believe, I haven't seen the police report, but from what I'm told from the parents in Kavan, is that no drugs were found in Kavan's room. It was all either found in the roommate's room or in the common spaces. So with that being said, I would say that he's not a flight risk. He's had no FTAs, no fleeing and eludings. I would say he's not a significant risk to commit additional felonies if he's released, as he doesn't have any felony convictions. Although I do recognize that, he was accused of felonies after being released last time on pretrial. But I would say that he's innocent until proven guilty on those new charges. He was originally released on pretrial release on this case. I would be asking that you either reinstate that, or if pretrial doesn't want to come back on that, I understand, and ask that you set a reasonable bond in this case. I did take note earlier I believe it was the first or second case on the calendar, when you set I believe it was a $3,000 bond on an entering auto. So I would just ask that you do the same thing here in this case, preferably $3,000 bonds on the 2 felony charges, and then $1,000 or $2,000 bonds on the remaining 3 misdemeanor charges.
Some Jotty.
Your Honor, given the fact that the defendant had an opportunity starting with a UJR and then became was rearrested subsequently, the state would respectfully request that the court impose reasonable bond amounts. We're requesting a bond amount of $5,000 for possession of tools for the commission of a crime, $10,000 for the charge of entering an automobile and theft by taking. With respect to the charge of giving false information to a law enforcement officer, we would request a $5,000 bond. And with respect to the misdemeanor possession of marijuana, a $1,000 bond, for a total of a $26,000 good bond, Your Honor.
Sir, is he still going to live on Danbury Lane?
No, Your Honor. He's going to be moving back in with his parents, which I think is probably the best option for him at this point. They live at 1905 Riverside Parkway. That's unit 215, and that's in Douglasville, Georgia. And the zip code there is 30135.
All right. No further contact with Alec, A-L-E-C, last name E-L-A-M. No drugs unless prescribed, no alcohol, no weapons. Stay away from 765 Madison Drive. No further contact with the co-defendant. First name I-S-H-A-Y-A-R, last name Y-A-S-H-A-R-A-T-I-A. And have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical, Why else would he need to leave his house?
School and work. His GED youth build program, so he can continue his education. He's 3/4 of the way through that, and then employment at Royal Roots Barbershop.
All right, for employment, you have to supply the name of your employer, the schedule, proof of employment, the location you'll be working, but it can't be in Fulton County because you're going to stay out of Fulton County unless you're here for court or to see your lawyer. No, absolutely no reason for you to come back to Fulton County, sir. You hang out there in Douglas County. So that, and like I say, work in any programs or you're in to get your GED.
Thank you.
So
Your Honor.
5,000, 7,000, 3,000, 5,000 and $250. 5,000, 7,000, 3,000, 5,000, $250. That ankle monitor, sir, be paid for by the county. Best of luck to you, sir. You can leave the booth.
Thank you, Your Honor. And that is my last case on the calendar today. May I be excused?
Absolutely.
Thank you. It's been a pleasure.
Have a good holiday.
You too.
What else do we got? Who else we got here? All right, do we have Bayman Hinton? Mr. Hinton. Mr. Hinton, wave your hand if you're here.
You got me, Daniel Kane, counsel for Bayman Hinton.
Yeah, he's not in the booth yet. Brandon Milam. All right, did anybody get here? Did Eric Johnson get here for Mr. Milam?
Your Honor, Eric Johnson will not be coming tonight and I'm going to handle it for him.
All right. This is Brandon Damon Milam, 22 CP 211724, 112 days without indictment, got criminal attempt to commit murder, aggravated assault with a deadly weapon, possession of a knife or a firearm during the commission of or attempt to commit certain felonies, death by taking misdemeanor. Trial. No bond as of August 24th.
Judge, 7 prior arrests, open case 22 SC 184143. Aggravated assault with a deadly weapon, 4 counts, cruelty first, 3 counts assigned to Judge Dunaway. Also just convicted of a battery, family violence, September 6, 2022. Nothing further.
All right, and go ahead, Ms. Rondon.
Mr. Milam is 30 years old and is from Atlanta. The last address I know of where he would reside is 2324 Martin Luther King Jr. Drive, Southwest, Atlanta, Georgia, 30311. He has no history of failing to appear, which would indicate that he is not a flight risk. It is my understanding that he was working as a warehouse worker for Smart Staffing, and it would be a possibility for him to get his job back. As stated, Mr. Milam has been in for over 90 days and is entitled to a bond.
Who is this that keeps stay on mute? Go ahead, Ms. Amjadi.
Your Honor, the defendant has 8 arrest cycles since 2010. In contrast to the information my co-counsel gave or opposing counsel gave, I did see that there was a charge for escape and failure to appear that appeared in his criminal history from 2016. He also has a pending case for 3 counts of aggravated assault that was from April of 2020. With all that in mind, Your Honor, and then on top of that, the allegations in this case, which were that he shot one victim 4 times in each leg, his chest and his neck, and then another victim in her leg. I think it's quite clear that this person presents a danger to the victims, harassment and intimidation, or possibly worse towards the victims, and that he presents a danger to the community, given that he has been reoffending with violent offenses. For those reasons, Your Honor, we would respectfully request that if the court is inclined to grant a bond, that it be very high and commensurate with the seriousness of these offenses and the threat the defendant poses to the community.
It looks like on the other ones, he made a $60,000 bond. I don't know if it's been, anything's happened to that. So no drugs unless prescribed, no alcohol, no weapons, no further contact with Maurice Hart. Mr. Hart, are you here? If you're here, turn your camera on. And Maisha Ingram. Mr. Hart, you got to turn your camera on. You have to turn your camera on if you're going to address.
I did.
Okay, hold on. No, it wasn't on. So hold on a second. Let's see. Do we have Maisha Ingram? No, Mr. Hart, raise your right hand for me. Do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes.
All right, sir. What is, he has been in 112 days without indictment. I'm statutorily required to give him a bond. Okay, so he has to have a bond. What are your thoughts?
No bond.
Okay, but did you hear what I said? He's statutorily required to get a bond. He has to get a bond. Are you scared of him? What is it you want to say to me?
My life in danger. I just don't want him to be out.
I can't understand you, sir.
I said, I feel like my life will be in danger. I just do not want him out.
Okay. All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with Maurice Hart. No further contact with Meicha, last name Ingram, Engram. Stay away from 1033 Hollywood Road Northwest. Stay away from Shauna's Apartments. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. Only reason you're to leave your house, sir.
Your Honor, may I also request that he receive precision location monitoring?
Okay, so you can put that in precision location monitoring. 50 on count 1, 50 on count 2, 25 on count 3, 10 on count 4. 50, 50, 25, and 10. No, hold on a minute. 75 on count 1. 75, 50, 25, and 10. 75, 50, 25, and 10. Best of luck to you, sir. Thank you, Mr. Hart. I'm glad you're better.
Excuse me, Judge.
Yes.
I heard the attorney mention something about precision location monitoring.
Yeah, just do that. Ankle monitoring / precision location tracking.
Okay, thank you.
Thank you. All right, let's see. Do we got Anwar Myers? All right, who's handling this one? You handling this one too, Miss Rondon?
That's my case, Judge. Ryan.
All right. So there's 3 cases,
Correct.
15, 16, 17 pretrial, 22 CP 212627, Anwar Myers Jr., 82 days without indictment. There's $105,000 good bond on this as of September 24th for aggravated assault, armed robbery, theft by receiving stolen property, and financial transaction card fraud. Position 16, 82 days without indictment, Anwar Myers Jr., 22 CP 212626, 1, 2, 3, 4, 5 counts of aggravated assault, and 1, 2, 3 counts of cruelty to children. There is a $280,000 good bond on that as of 9/24. 17, 22 CP 212569, Anwar Myers Jr., 82 days without indictment. There is a $2,500 split bond on carrying a weapon within school zones and possession of marijuana less than an ounce. Rob.
Only prior arrest, Judge.
All right, go ahead, Mr. Tevis.
Judge, to save time, I'm not here to address 212569. The nature of my motion was with regard to the amounts and the other 2 bonds. Statutorily, the bond statute requires under subsection E for the court to consider the financial means of the defendant. My client's 18 years old. He is in the 12th grade at Langston Hughes High School. He does not have the means to pay such a bond as this. He would reside with his father, who's a truck driver, who said he could probably make a $50,000 bond, pooling the resources together with his wife, Michelle Myers, who I believe is on Zoom as well. My client has no prior history. He's presumed innocent of all the allegations in this case. I will say the number of charges is a little bit misleading in that the one case, 626, with ag assault ×5, the allegation in the warrant is that there was a firearm pointed at a vehicle. And I guess the vehicle was occupied by multiple people. But the amount of bond here is extremely high, does not seem calculated at all to ensure his return to court, which is statutorily required. A bond amount this high is tantamount to no bond at all, which is not what the law is prescribed to do. So with the 627 case, it already has an ankle monitor to be paid by the county. I think that's appropriate. He has no history of FTAs, no indications that he would flee the jurisdiction of the court or that he wouldn't appear. His father owns a house here. I can provide that address offline as to where he would reside.
Where's it at? Atlanta? Where's it at?
The address is in Atlanta, Judge.
Okay, go ahead.
30213, and I can give the actual address. But if I'd like to not do that if we're streaming. So I think that the amount should be reduced. The ankle monitor is sufficient. He can be under lockdown other than meeting with me or going back to school, or if he goes to school online, that would be fine as well. But right now he's waiting for indictment. I don't know when that's going to be. Based on my experience, it's probably going to be a while. We haven't had a preliminary hearing, and he's presumed innocent of these charges. So I think that a bond, $50,000 is what his family can make. I know the court may find that that may not be enough on these cases, but I think somebody putting their life savings up plus an ankle monitor is going to ensure that he'll return to court. There's no evidence that he'd be a danger to the community, no prior history, no prior felonies. And so we'd ask the court to reduce the bond substantially.
All right, Mr. Tevis. So the offense date on the 1, 2, 3, 4, 5 ag assaults and the cruelty was 8/25/2022. The offense date on the armed robbery, ag assault, theft by receiving, that's 9/21/2022. And then weapons in a school zone and possession of marijuana less announced is 9/22/22. Those are the actual offense dates. All right. So mind you here, also I have to consider that poses no threat or danger of any person in the community or to any property, poses no significant risk of committing a felony pending trial, poses no significant risk of intimidating witnesses, otherwise obstructing danger. All right. So, and, you know, also knows not supposed to commit another felony while he's out on bond. Some Jotty.
Your Honor, the defendant has already shown that he is going to reoffend if let out on bond. I understand that he already has.
I would ask the state to cite the evidence for that assertion.
He has 3 cases acquired within a month of each other.
And he's presumed innocent constitutionally. So the state actually has to provide evidence of prior convictions, Your Honor.
All right. Well,
Your Honor, there are no prior convictions because he's 18 years old.
Right.
But the second he turned 18, he racked up 3 very serious cases. Additionally, the presumption of innocence, Mr. Tevis,
Excuse me. I'm sorry, I can't get everyone.
Right. Okay. So one at a time, Mr. Tevis. Be cool. Let Miss Amjadi talk. It's always go smooth on public defender days. Okay. You got to
just
hold on. No, stop. Don't interrupt me either. Okay. You can't. Miss Gandy is taking it down. I tell you what, the punishment for the next person that talks over somebody is you're going to do Miss Gandy's job for an hour. You are going to take down a case for 1 hour. I don't care if you type it, handwrite it, Morse code it, but you're going to see how frustrating it is when people talk over one another. Let Miss Amjadi talk. I'm smart. I'm so much smarter than I sound, Mr. Tevis. I know you don't believe it. Like I said, cornbread and buttermilk every time I open my mouth with this accent. But guess what? I am smarter than I sound, and I prep all these calendars. So I've read every single word and everything that's on there. Go ahead, Miss Amjadi.
Thank you, Your Honor. I appreciate that. I understand that he has received a bond in these cases, so it's not a question of whether he should receive a bond, but rather what that bond should be. However, these bonds that have previously been set have been abundantly fair and reasonable given the severity of the allegations and additionally the defendant's apparent proclivity for reoffending. These actions constitute a danger to the community, persons, and property therein. Additionally, Your Honor, while I do appreciate the presumption of innocence and it exists for every case that comes before us, as far as a bond argument, when somebody has 3 cases that were acquired within a month of each other, well, as I learned when I accidentally set fire to my multi-pot, where there's smoke, there is fire. The standard here is probable cause, and we have met it. For those reasons, Your Honor, the state respectfully requests that bond remain at the amounts it has been set at. With respect to the 22 CP 212569 case, Your Honor, procedurally, did pretrial revoke that bond?
Bostic, are you guys coming off that? I didn't know these 3 cases while y'all are on a pretrial for the marijuana less than an ounce.
We were.
Yeah, on the one in 569, y'all are on that. Do you know if you've came off of it? Because if you have, I want to go ahead and address it while they're here instead of Mr. Tevis having to come back.
Your Honor, if I could address, I could save the court time. He was booked in on all 3 of these at the same
time.
He's never violated his bond.
All these say surety bond. What do y'all see that is a pretrial bond?
There was a UJR for the misdemeanor. I'm sorry, Your Honor.
Yeah, there's UJR ending in 569.
569.
Possession of marijuana less than an ounce. All right, position 15.
Oh, that's why somebody here's you know what they do, Judge. On all the other charges, they can't give him a pretrial bond. So to give him supervision they will put it on the lowly misdemeanor on the armed robbery cases,
All right.
which
All
it
right.
should not be.
Right. On position 15. No drugs unless prescribed, no alcohol, no weapons. No further contact with Alston Malone, Malone, ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, medical. Anything else he needs? He's only, what, 17, 18?
18, Judge.
18, Your Honor.
Court, lawyer, and medical. 24 hours. No weapons. Let's see, stay away from 5150 Thompson Road in Union City. Count one, I'm gonna leave at 50. Count three, I'm gonna leave at 30. Count three, I'll reduce to 5. Excuse me, 50, 35, and 5. 50, 35, and 5. Let me make sure I got this. Okay. Let's see, position 16. No drugs unless prescribed, no alcohol, no weapons. There's ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, and medical. That's the only reason you're gonna leave your house, young man. No further contact with the victims. Latoya Denham. I don't know if any of these victims are on here. Miss Denham, Denham. Cordell Lavelle, Kordellevell. Deja Denham, Dejadenham. London Arnold, Londyn. Latavia Denham, Lataviadenham. I don't see anybody's camera coming on, so I'm assuming that none of those folks are here. Stay away from 4740 Jonesboro Road in Union City. I think I already said it. No drugs, no alcohol, no weapon. That ankle monitor is going to be paid for by the county with a 24-hour curfew. I'm going to leave all the ag assaults. Let's see. 40, 40, 40, 40, 40, 7, 7, and 7. 40, 40, 40's on the ag assaults and 7's on the cruelty. Ms. Weston. All right. Position 17. No drugs unless prescribed, no alcohol, no weapons, no further contact with Octavius, Octavious Harris. Let's see. You're going to have a 24-hour curfew except for court, lawyer, and medical. Stay away from 7510 Hall Road in Fairburn. That ankle monitor will be paid for by the county with that 24-hour curfew. I tell you what, here's what I'm going to do because pretrial really don't want to do that. 2,000 on count 1 and 500 on count 2 because pretrial is going to come off of Mr. Tevis. They're just
I don't think he'll make this bond, but I also don't think they can come off a bond when there's no petition to revoke. Like he's never violated it.
Trust me, something will happen. They will because they will. So it's fine. So it's the same price. But that ankle monitor is going to be paid for by the county. There'll be an ankle monitor on that also. Best of luck to you, sir.
Thanks, Judge.
Thank you. Have a good holiday. Bayman Hinton. Mr. Hinton, did you show up in the booth? Mr. Hinton, wave your hand.
Oh, all right, Daniel Kane's here.
Yeah, I got you. I don't see Mr. Hinton, though.
Is
right,
there somebody in charge of getting him in the booth?
All right, so here you go. Once again, I'm on now says one more time for everybody. There is one deputy that are pulling these inmates. One. Unless somebody wants to go down to 901 Rice Street and help them, we're going to be very, very patient for them. So they're pulling them as quick as they can. So we got to just go through the ones that are here, but they only got one deputy that's doing it. So we're going to be patient with that deputy. We'll come back to it and I'll check when I see somebody come in there. Roderick Nance. Mr. Nance. Nance, there's Mr. Nance. There's Mr. Hudson. Kobe Hudson.
I don't see him, Judge. I'll email him.
All right. Let's see. I see that Mr. Johnson's on here. Mr. Johnson, Ms. Rondon handled your case for you, I think. Didn't you, Ms. Rondon?
Yes, I did for Brandon Milam.
Right. Mr. Johnson, Ms. Rondon handled your case. So you owe him. You owe her at least handling 2 cases.
Okay, no problem, Your Honor.
All right. Have a good holiday.
Thank you. You do the same. I will be in touch, Ms. Rondon.
Okay.
All right. Do we have Gerada Henderson? Mr. Henderson? All right. We got Mr. Majeski on here. I think so.
He just
Right.
wrote a chat message.
Yes, Judge, I'm here.
Okay, here we go. Position 7, Gerarda Henderson, 22 CP 212-297. 91 days without indictment. There is no bond on armed robbery, possession of a non-firearm during the commission or attempt to commit certain felonies, and theft by receiving stolen property misdemeanor. Wow.
Judge, in regards to Henderson, no prior arrest.
All right, go ahead, Mr. Majeski.
Good evening, Judge. First of all, sorry about being a little late. Technology will be stubborn sometimes, but
That's okay.
my client is 19 years old. He's lived his entire life in Georgia, all of that in the metro Atlanta area. His entire family lives here. It's a very extended family, mom, grandparents, uncle, 3 sisters, 2 brothers. And, he's got ties to no other community except for this one. He has no prior arrests, not even convictions. So obviously no probation violations or FTAs. He was set to complete his GED program this fall. That's obviously been frustrated since his incarceration has been since September. As far as employment, he could have employment, any number of places, but he is an engineer in the music industry, works with several local artists, was actually being looked at by Epic Records before he was arrested. Judge, as far as the nature of the offense goes, I'm a little bit at a loss here. Like most of these cases, I have no knowledge of what happened because I have not been to a preliminary hearing. However, the limited information that is available to me, I understand is mostly a party to a crime case, and my client was not alleged to have been the principal. Given that, Judge, I don't think he's a danger to the community, not a risk to flee, and I asked for a total bond in the amount of $35,000.
Ms. Jotty.
Your Honor, this is the defendant's first arrest. He's only 19 years old. But the state also has to balance that interest and those facts along with the fact that these are very serious charges, ones that pose a danger to persons and property within the community. For that reason, we would respectfully request, Your Honor, additionally, the theft by receiving stolen property charge, it's listed as a misdemeanor, but it was a stolen firearm, which I believe by statute makes it a felony.
Right.
Given all this information, Your Honor, the state would respectfully request a bond of $40,000 for each of these offenses, plus ankle monitoring and house arrest, with the usual exceptions of medical and legal appointments, no contact with the victim in this case, no social media usage, and no firearms or firearm replicas, please.
Is he going to be living at Peg Road, Mr. Majeski?
I understand his mother just moved, and I was not able to get that new address today, but I can provide that to anybody who needs it.
Let's see. Sir, you going to be living in Fulton County? Thumbs up or thumbs down? Sir, are you going to live in Fulton County? I need a thumbs up or a thumbs down. He has no idea. It's kind of like, yeah, don't know, blew my mind. I don't know what that was, but okay. All right. No further contact with your co-defendants. AMADI, last name Mason. No further contact with DeMario, DEMARIO, Stringer, STRINGER. No further contact with Jaquavius, JAQUAVIOUS, last name Britton, BRITTON. No further contact with the victim, Denard Hillen, HILLAN. Stay away from 1097 Lena. Just said Lena in Atlanta. I don't know if that's a road or a street. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical appointments only. Since you think you're going to be moving, so you got to put in your change of address. Your attorney can file it with the court. Looks like I read it. Looks like on here there were allegedly 4 individuals and 3 weapons. Let's see, 30 on the armed robbery, 20 on possession of firearm during the commission of certain felonies. I'm going to make it 10 on the theft by receiving stolen property. That is a felony. Best of luck to you, sir. 30, 20, and 10. Thank you, sir.
Well, thank you, Judge. Thank you.
Thank you. I think you may have one. Oh, no, is that your last one? I think the rest are Mr. Manel.
Judge.
On the add-on.
Judge,
Yes, ma'am.
do you want me to upgrade that theft to a felony?
Yes, ma'am, if you don't mind. Did you say?
Judge,
I'm sorry, Mr. Robinson, did you say he had an add-on?
He's on the add-on. Mr. Majeski has another case on the add-on.
Which one is that?
The
Is that Johnson?
I'm so sorry. I think it's Melnick. I'm sorry.
It's me, yes.
Okay. Thank you, Mr. Majeski. Have a good holiday.
Thank you, Judge. I'm frequently flattered to be mistaken by such a fine jurist. Have a good evening, everybody. Thank
Sorry
you.
DeKalb County kept you so late. You know how they can be.
Yeah.
All right. That was for you, Ms. Robinson. Mr. Melnick, let's see if Paul Hill, if you're here, raise your hand. There's Paul Hill. 21, Bostic. 22 CP 212744, 75 days without indictment, 2 counts of aggravated assault, no bond as of September the 29th. Rob.
Judge Paul Hill, 19 prior arrests, on probation for conspiracy to commit a crime, sentenced in 2013, 5 years confinement, 5 years probation. 04, a prior controlled substance and a prior assault conviction, nothing further.
All right, go ahead, Mr. Melnick.
Thank you, Judge. Just for clarity's sake, that sentence has actually expired, the 2013 case. There is no longer any probation on that case. He was in custody for a period of time before he was sentenced, so the case has expired. Just for clarity's sake.
Oh, okay.
Other than that, Your Honor, he is 41 years of age. He lives in Atlanta. He has 3 children that all live here in Atlanta. He has been gainfully employed. He has actually, since he got through with all the trouble in his life, the previous trouble in his life, he has been a model citizen. He was working for a company called Condo Construction, and that employment is still available. His boss's name is Dennis Bossat, Bossat, and he has confirmed with me that Mr. Hill has been an excellent employee and has been a very created a lot of benefit to the company that he was working for. He was also working another job for Google Logistics. So he has tried to be as productive as he can. Your Honor, it wasn't Miss Amjadi, and I don't know if she's the DA that's handling this case, but I had previously sent to the Fulton County District Attorney's Office a video and several photographs where Mr. Hill was struck with a firearm by one of the 2 alleged victims in this case. And when I say struck, I don't mean shot. He was hit in the head with the butt end of a firearm. And he has multiple scratch and stab wounds from where he was attacked and was defending himself. And I can share that with the court. I can screen share it, or you can take my word for it as an attorney and as an officer of this court, that there's about a 4-minute video of Katrina Satterwhite holding a knife in her hand and essentially threatening Mr. Hill with that gun. Other than that, Judge, I recognize that he does have some prior history that dates back quite a number of years, but he has been in custody for 74, 75 days. And I think that a reasonable bond should be granted in this case. What I'm asking you to do is grant a $10,000 bond on each count, $20,000 bond total.
So are you saying that the on 925 that she allegedly hit him? Because in the warrants it says that she was stabbed in the back left shoulder and
I believe it was Tracy Satterwhite that
Tracy was stabbed in the leg and Miss Katrina was stabbed in the back. I think so. And I see the Satterwhite here. Miss Amjadi, do you want to hear from them first or do you want to go ahead?
Yes, please, Your Honor.
All right. So Miss Tracy Satterwhite, if you could raise your right hand for me. You swear firm testimony you're about to give is the truth, whole truth, nothing but the truth.
Sure.
I'm sorry. Yes. I thought I saw Miss Katrina Satterwhite. Maybe she dropped off. Well, okay. So what would you like to say, ma'am?
At the incident at hand, whatever happened with him and Katrina happened before I got there, as I stated to the police in my police statement.
So hold on, Ms. Satterwhite. All I really want to know, it's not time for you to testify about that. What it was time for is you just comment on bond. Sorry, I didn't mean to interrupt.
He don't need a bond. He's been contacting my sister to send messages to me from the jail of me threatening to drop these charges, this and the third. So I don't feel like he need a bond. Yes, he has been in touch with the law enforcement before, but that wasn't a lesson that he learned the 5 years that he was there. He came out of jail and still did domestic violence to the same woman that he have kids with after 5 years of being in prison for a murder. So no, I don't think he deserved bond. I think he need to sit there and think about his consequences of his actions. I was not there taking sides, and he knows that. And I was there trying to deliberate the incident altogether. I tried to get him to leave. I was more concerned of what she had done to him when I got there. So no, he don't deserve bond. He attacked me instead of just trying to leave. He had more than an opportunity to leave at home, and he didn't choose not to. He wanted to be a bear. He wanted to do intimidation. I'm 115 pounds, Your Honor. He's 200-something pounds, period. He was already in flight mode and attacked her before I even got there.
All right. Thank you, ma'am. Go ahead, Miss Let me hear from the DA. Go ahead, Miss Amjadi.
Your Honor, if I may just clarify a couple of things. The defendant in 2019 had about 17 prior arrests. I don't have a more recent criminal history, unfortunately. I would like to clarify he did have a 2008 conviction for aggravated assault. His 2013 conviction was for conspiracy to commit aggravated assault. He was a co-defendant on a case that was primarily a murder case, but he himself was not convicted of murder.
Okay.
I just wanted to clarify that for the record. And there was also a 2011 conviction for robbery by force, aggravated assault with a deadly weapon, and then the 2 possession of a firearm charges, Your Honor. The state's concerns here, Ms. Satterwhite has indicated that she is in fear for her own physical safety and that she is opposed to the court granting any bond prior to it being absolutely necessary or statutorily required. What I think is of more concern than that even is that she's been receiving pressure from her sister to withdraw the complaint and dismiss the charges. Her sister is still regularly speaking to the defendant. And while we know that that is not unusual in a domestic violence situation, this is not the first time that this couple has come before the court in a case involving allegations of violence. And I do believe it is in the best interest of the safety of both Ms. Satterwhite's that the defendant remain in custody, as well as the fact that the court should consider that he presents a threat to the safety of persons in the community, given his criminal history. And for those reasons, Your Honor, we would respectfully request that the court not issue a bond at this time.
All right. So you're saying that Katrina Satterwhite he's been in contact with Katrina Satterwhite?
Yes, Your Honor, that is his partner.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact, sir. None. Zip, zip. No contact. No carrier pigeon, no Morse code, no telling somebody's mother, sister's cousin, or brother to contact either one of these ladies. That would be a violation of your bond. And guess what? The DA's office pulls them. They pull your phone records. And they'll pull everybody else if you use somebody else's little card, okay? No contact, none. With Katrina, Catrina Satterwhite, let me make sure I spell this right, Satterwhite, and no further contact with Tracy Satterwhite through a third party or anything, sir. Stay away from 143 Peyton Place Southwest. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. You can leave for a court, lawyer, and seek medical treatment. Right now, there's only 75 days. So there's going to be no bond. Mr. Melnick, we could probably get you on back in January.
Okay, thank you, Jay.
Best of luck to you, sir. You can leave the booth. Don't go make a call. All right, let's see. Did Mr. Hudson get here?
I'm here, Judge. I'll take that spot.
Oh, for Roderick Nance?
Judge, just to say about Mr. Hudson, he also too was in DeKalb earlier today.
In DeKalb County. All right, let's see. Let's see who else we got here. So do we have?
Judge, that's my client in 6 North. Contavious Wright.
Contavious Wright, okay. Contavious Wright. That's position 1, 22 CP 211641, 116 days, no bond. Got Ms. Patel on here. Cruelty to children in the first degree, unlawful for a person employed by, associated with criminal street gang to conduct or participate in criminal street gang activity. That's 1, 2, 3, 4, 5 counts of that. And then 1, 2, 3 counts of unlawful for a person to commit offenses with intent to obtain, earn membership, maintain, or increase status in a gang. And there is an aggravated assault, aggravated battery, criminal attempt to commit murder. I think I missed anything. No bond as of August the 20th. Rah!
As you know, it's 4 number 1s today.
What's that?
It's 4 number 1s today.
Oh, yeah, I'm sorry, this one. Oh, yeah, and
I
Mr.
got it, though.
All right, and Mr. Melnick, sorry about that. There are there are warrants out right now that were issued 8/27, in case you want to know: armed robbery, kidnapping, ag assault, possession of not for a firearm during commission, receipt, transport, firearm by a convicted felon. And it looks like there may do more possession tools for a crime, theft by receiving stolen property, criminal damage to property, willful obstruction, and driving without a license, theft by receiving stolen property. Go ahead, Bostic.
Judge, in regards to Mr. Wright, 10 prior arrests. He has at least 4 prior convictions. Entering auto theft by receiving in 2016, theft by taking and fleeing and looting 2016, 2019 tools, 2016 aggravated assault firearm. Open case 22 CP 205821, armed robbery, firearm doing, firearm by, battery, substantial harm, and simple battery. Nothing further.
Go ahead, Mr. Melnick.
So, Judge, are you saying those open warrants are from a previous case?
Well, it shows that they're pending warrants. So I'm just telling you that. So if they've already been handled, you may want to get in touch with the jail. But I'm just letting you know that they're there in case, he posted, but they're showing up. So
I got you.
Just for your own edification.
Okay. All right. So I'll have to look into that. So, Your Honor, Mr. Wright is 24 years of age. He has extensive family that lives here in Atlanta. He has been gainfully employed. His family owns and operates a cleaning service, and he will be able to go back to work for them with them when he is released from custody. Your Honor, obviously, I recognize that these are very serious charges, but what the arresting officer did in this case was take out a number of warrants that are sort of alternative charges of the same offense. And I know you've read through the warrants, but I would ask you to take that into consideration when you set him a bond. He is legally entitled to a bond on this case, Your Honor. So I would ask that you grant bond commensurate with the fact that he's been in jail for close to 120 days. With
116 days.
Yeah. Your Honor, what I'm asking you to do is grant an aggregate bond in the amount of $75,000 with whatever conditions you deem to be appropriate.
Mr. Melnick, he's going to live at that Mapleton address.
Is that right, Mr. Wright? I actually have a different address from that. Okay.
Thank you, sir. Ms. Patel, I think this is hers, right, Ms. Amjadi?
Your Honor, I think this was actually supposed to be handled by one of the organized crime units.
I'm sorry.
I apologize, Mr. Melnick. What were you saying?
Not a human trafficking case.
I thought you might have wanted to waive sounding.
Did you want to?
If the court would not mind returning to this one, and I apologize, Mr. Melnick, for the inconvenience to your schedule, if I can try to get ADA or Deputy Winfrey to come back.
Oh, okay.
If not, I can. I have a partially prepared argument to handle this.
Okay. All right. Let's see. So hold on. Okay, Chad Dabney. There we go.
Judge Attorney Leah Madden here on behalf of Mr. Dabney.
All right. Position 3 on one of the calendars. Chad Dabney, 22 CP 212-168, 96 days without indictment. There's no bond in 4 counts of trafficking illegal drugs. Possession of Schedule 3, 4, or 5 controlled substance with intent to distribute. That's ×2. Possession of firearm during the commission of a felony or attempt to commit certain felonies. Possession of firearm by a convicted felon. misdemeanor obstruction and possession of drug-related objects. Rob.
In regards to Mr. Dabney, 8 prior arrests, convictions, 05 controlled substance, prior, something 14 SC 130070. He's still on probation for it, sentenced 5/2/2016 for 10 years. Didn't write down what the charge is. And then for aggravated assault with a deadly weapon, firearm by 19 SC 169874, sentenced in 2020. And then there's 19 SC 170057, sentenced the same day. For cocaine with intent, marijuana with intent, Schedule 2, firearm by, firearm during, 18 months confinement, 8 years, 6 months probation. Nothing further.
All right, and just so you know, there is a probation warrant, 22 PV 000021, open and with Judge Ingram, just so you know, Ms. Madden.
We've actually handled that, Your Honor. He got
Okay.
revoked.
Okay. Go ahead.
Yes, Your Honor, just briefly, my client is 37 years old. He's a lifelong resident of Atlanta, Georgia. If he were to receive bond, well, he's entitled to bond at this point. His address would be 1456 Copeland Avenue, Atlanta. He has substantial ties to the community. All of his family members live here. I think he had a brother that was on the Zoom call, but I don't see that he's still here. But he has one child, a 9-year-old daughter. Prior to his arrest, he was working. He was gainfully employed at the Gatorade plant on Westgate Parkway in Southwest Atlanta, Georgia. He had been working there for over 3 years as a forklift driver. Judge, with respect to the probation, we've already actually handled the probation revocation before Judge Ingram. He was revoked 12 months. The basis for that were these new charges. Obviously, the case has not been indicted, so I don't have access to full discovery, but I did get some information in preparation for the revocation hearing. And from what I can gather, it looks like this is a mere presence case. I understand, obviously, the very serious nature of the charges alleged, but it doesn't appear that he was the target of the search warrant. I don't believe any drugs or any guns were found on his actual person, that he essentially was just present. Again, he has been in excess of 90 days, so he is entitled to bond. I would ask for an aggregate bond not to exceed $60,000 with whatever conditions Your Honor feels are appropriate.
All right. So according to this, there's 32.8 grams of MDMA, 24.4 grams of heroin, 156 grams of crack, 64.3 grams of Xanax, 12.3 grams of oxy, and 13.88 pounds of marijuana. Miss Samjadi.
Your Honor, given the quantities and the defendant's criminal history, he's had 9 arrest cycles since 2005, the vast majority of which have had some sort of drug-related nexus. There was a 2005 felony VGCSA conviction. There was a possession with intent for cocaine in 2016, along with firearms. In 2020, there was an anomaly for his history, not involving drugs, but there was an aggravated assault with a deadly weapon, in addition to a possession of a firearm by a convicted felon charge. And then in 2020, he was convicted for possession with intent to distribute cocaine, possession with intent to distribute a Schedule 1 or 2 controlled substance, and then possession of a firearm by a convicted felon and during the commission of a felony. Given all of that, Your Honor, and the charges before the court today, which appear to be an escalation of a previously established criminal pattern, the state would respectfully request, given that the defendant is now legally entitled to a bond, that any bond the court issues be no lower than $100,000 for each of the trafficking charges, no lower than $10,000 for the possession with intent charges regarding the Schedule 3, 4, or 5 controlled substances. With respect to the possession of a firearm during the commission of certain felonies, we would ask for a $40,000 bond given the high incidence of violence surrounding drug sales, $40,000 for possession of a firearm by a convicted felon, given the prior aggravated assault conviction as well as several other convictions. And with respect to the misdemeanor charges, $1,000 for each, Your Honor.
Is that by Judge Brasher, which I guess one Judge Glamp, I'm assuming is going to be adopting? Is that according to his standing order?
I may have to check on that, Your Honor.
Okay. All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with co-defendant Quenson, Quenson, last name Beavers, Beavers. Stay away from 1295 Donnelly Avenue. Ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical attention. And I think those are the trafficking is in line with the standing order. So 100,000 per trafficking, 50,000 Schedule 2, Schedule 3 on both those. I mean, Schedule 3, 4, and 5. Possession or not for a firearm during the commission, 30. Possession of firearm by a convicted felon, 30, and 1 on the 2 misdemeanors. 100, 100, 100, 150, 50, 30, 30, 1, and 1. You got that, Ms. Weston? Uh-oh. Ms. Weston, did we lose her? Oh, no. You got that, Ms. Weston? Miss Road thing. Ronite, you got it?
I got it, Judge. Thank you.
All right. Thank you, sir. You could leave the booth. And if that's all for you, ma'am, you can go ahead and leave and have a good holiday.
Thank you, Judge. You also.
All right. Let's see. Do we have Raylick Lampley here? Lampley, there he is. Is this a conflict case, Ms. Rondon?
Yes, it is.
22 CP 210859, 363 days, no indictment, aggravated assault, aggravated battery, no bond as of August the 23rd. Wow.
Judge, I'm sorry, I didn't hear the name you said.
Raylick Lampley. Lampley.
Oh. Judge, in regards to Mr. Lampley, 5 prior arrests. Open case 22 SC 183886, criminal attempted burglary, criminal trespass assigned to Judge Cox. On probation, first offender, Palm Act. Interference with government property and felony obstruction, sentence May of this year, 2 years, nothing further.
All right. Now, Ms. Rondon, I think this event happened at the jail. So, because it was July the 12th. Looks like the victim was, another inmate was stabbed somewhere near the heart, but go ahead.
Yes. Mr. Lampley is 20 years old and is from Atlanta, Georgia. When he makes bond, Mr. Lampley would stay at 3080 Cadiz, CADIZ Circle, Atlanta, Georgia, 30349 with his mother, Miss Latonia Lampley. Prior to being in custody, so back in 2021, he was working in lawn care, lawn maintenance. It is my understanding that he does not have a history of failing to appear for any required court dates. We would be asking the court to set bond in the amount of $20,000, $10,000 for the aggravated assault, and $10,000 for the aggravated battery. Thank you.
Thank you. Miss Amjadi.
Your Honor, this is, after having done this for about 15 years, I rarely see a fact pattern that makes me flinch quite as much as this one did. As the court previously mentioned, the victim was stabbed multiple times around his heart with a shank in the jail. Your Honor, I did reach out to his prior counsel to see, whether we should communicate with him and see whether he had any position here. But she was actually unaware of this situation. So with that in mind, Your Honor, the state would respectfully request a high bond amount commensurate with the seriousness of this offense. We would ask that the court issue a bond amount no lower than $100,000 for the 2 charges.
100 total?
Yes, please, Your Honor.
All right. 100 total, 50 on each. No drugs unless prescribed, no alcohol, no weapons, no further contact with Allen, last name Anquavius, or maybe it's Anquavius Allen, ANQUAVIOUS. Ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. Best of luck to you, sir. You can leave the booth. that it for you, Ms. Rondon? Or wait a minute, you got one more. Alfred Dodd.
Excuse me, could you repeat that address for me again? I just have Cadiz.
Where he's going to be living. She said 3080 Cadiz Circle.
3080. That's what I needed. Thank you.
Yes.
Alfred Dodd, we're actually going to reset his case out. Attorney Luembe sent us an email saying he's not ready.
Okay. All right. Did you get in touch with the gang unit folks, Ms. Amjadi?
Your Honor, I sent an email and I didn't get a response, so I'm going to try sending a call now.
Okay. Let's see.
I may need to step away in order to do that.
Okay. So which one are you here on, Ms. Patel? Maybe I can.
Sorry, Your Honor, I missed that. I was on a call. Would you mind repeating?
Which case are you here for?
I'm here for Mr. Thornton.
Thornton. Okay. We'll let Ms. Amjadi make that call. Hold on a second.
Your Honor.
All right. Tyler Thornton, are you there? All right. Ms. Taylor.
All right.
All right. All right, 22 CP 211971, Tyler Thornton, 102 days for no indictment. Right now, there is a $5,000 split bond. There's no bond on the gang charge. As of September the 3rd, possession of manufacture, distribution, sale of marijuana, and unlawful for a person employed associated with criminal street gang to conduct or can participate in criminal street gang activity. Free. Raw.
One prior arrest, Judge, no conviction, nothing further.
All right, go ahead, Ms. Taylor.
Judge, on behalf of Mr. Tyler Thornton, we don't understand the gang charge at all, Judge. And I know you've read the warrants and our yellow factors I'll give you on Mr. Thornton. But Judge, he denies any kind of involvement in any gang. I don't know why they have that. He doesn't have any social media, no gang ties at all. No gang arrests or anything. They're giving him a $5,000 bond on the marijuana. Then they come back and throw this gang charge on him. We don't know why. His Ayala facts, if you heard, just this young man has no prior convictions for anything. He is 24 years old. He graduated from South Atlanta High School in 2017. He has 3 children and a baby on the way. My understanding is that they're supposed to induce labor on the 23rd. He does want to be present for the birth of the child. Working judge, doing construction work. Doing warehouse work. His entire family, mother, sister, children are all here. He's an Atlanta native. I don't see any need for him to even have an ankle monitor. I know that's a pattern of the courts. I understand that. But this man has no prior convictions, Judge, at all. Not a flight risk. Not a threat to continue committing crime. I asked the court to grant a $5,000 bond on this gang charge, this preposterous gang charge, and a $5,000 bond on the marijuana.
All right, Ms. Patel.
Thank you, Your Honor. The defendant was actually surveilled upon by Detective Storno of APD. He was seen associating with his co-defendant, Mr. Jarrell Williams. This case involved 1.5 pounds of marijuana. There were also, Detective Storno, over the span of 2 days, had surveilled and seen Mr. Thornton going to different locations and would be holding a long rifle, assault rifle, along with his co-defendant, Mr. Williams. The areas that they were selling or were observed selling this marijuana was in an area that is known for the Crip gang, the Rolling 60 gang members. Specifically, the homes that they were selling in is known for that, for the sale of marijuana in those locations. Storno monitored these apartments over that full day. Every time they would come outside, they would see that same pattern. For that reason, the state had taken out APD had taken out the gang warrants. We'd ask Your Honor to set a bond of $500,000 as this is a gang case, and the statutorily, the court is allowed to post or to assign a high bond based on the fact that it's for gang activity and there are guns involved.
Judge, if I could respectfully to the state,
You are incorrect. You're stating the facts incorrectly. Okay. If you look at, and the judge has read the warrants and read the probable cause on the warrants, there was no surveilling of Mr. Thornton for 2 days. They were surveilling at a gas station. They saw some people out there. Mr. Thornton comes up in a vehicle driven by Mr. Williams. Mr. Thornton gets out and goes in the store. Mr. Williams has a gun in his hand. Mr. Thornton never had a gun. Nobody never seen him with a gun. Judge, I know you've reviewed the warrant. They leave the store because Mr. Williams is driving a BMW SUV. They follow him. They followed him to an apartment, which is Mr. Thornton's brother's apartment. Mr. Thornton was there washing clothes, told them that. They said they observed, they sat there surveillancing for an hour or two. They saw Mr. Williams come out of the apartment and go to the car on several occasions with a gun in his hand. No transactions with anybody. Nobody going to this apartment doing anything. If you look at the warrant, it says that, okay? They come out. When they come out, they create a reason to stop Mr. Williams, who is the driver, okay? That's how they get arrested. They actually told them we were there washing clothes. They actually get a search warrant, Judge, and go back to that apartment. Nothing, no drugs, no weapons, nothing is in that apartment. There was no transactions by anybody. Nothing. They wasn't surveilled for 2 days. It was for 2 hours. They didn't see Tyler Thornton doing anything but carrying a backpack. He wasn't carrying a gun. He has no history of gang activity. I looked up Mr. Williams. Mr. Williams has never been arrested or has no history of gang activity. They want to associate. I'm not arguing for Mr. Williams. I'm arguing for Mr. Thornton. Because he went to a gas station on Cleveland Avenue. Oh, this area is known for the gang members. That doesn't put you in a gang. It doesn't put you associated with a gang. This man went in the store. Nothing, Judge. They did not see him making any transactions. Never saw him with a gun. So respectfully, she is wrong. She stated the facts incorrectly as far as what's in the warrant and the affidavit. This man has of drug activity, no history of gang activity. And asking for a $500,000 bond does not meet the Ayala factors. There's way beyond that. They want to put everybody in the daggone gang because of a neighborhood. You can't be in a neighborhood unless you're in a gang. He has nothing, no history of gang activity. None. No warrant, no tattoo, no symbols or anything, Judge. This man is entitled by Ayala to a reasonable bond. He is presumed to be innocent as the court is aware of. And I'm sure you've reviewed the warrants, Judge. And what I've stated is the facts as in the warrant, not what the state stated. And to ask for a $500,000 bond on a young man who
Judge, at this point, I object. Ms. Taylor, I believe has made her record clear. At this point, it's becoming, I object to this rhetoric, essentially.
So like I said, I see in here where it also said Investigator Ernest confirmed Jarrell Williams and Tyler Thornton as an Atlanta Crip gang rolling 60s gang member since at least 2021. However, anyway, all right. So no drugs unless prescribed. No drugs unless prescribed, no alcohol, no weapons, no further contact with Jarrell, Jerel, Williams, no further contact with any, and no replicas of weapons, Ms. Jamie. No further contact with anyone associated, members, pledging members, wannabe member, thinking about being a member of the Atlanta Crip gang and rolling 60s.
And he didn't have a weapon. You saw that in the warrants, Judge.
So we got income monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. Sir, you say he's expecting it? He's got a baby on the way?
Got a baby on the way, Judge. They're going to induce on the 23rd. And his family can't bond.
Okay.
Okay.
Employment, you got to give the name of your employer, the exact location you're going to be working, proof of employment, and your schedule every week to the ankle monitoring company and to your attorney. Is he going to live on Rogers Avenue?
Thumbs up if you are, Mr. I actually asked them. I know they said he lost his apartment.
All right, hold on. Sir, are you gonna live in Fulton County? Thumbs up or thumbs down? All right. So let's see. 60s. Oh, no replicas of weapons. So 5,000 and 100,000. Best of luck to you, sir. Oh, and you can leave for birth of the child or medical appointments for the baby.
They can't make no $100,000 bond. That's just he's not no proof, no kind of game. But anyway.
All right. Best of luck to you, sir. Let's see. We got Terrence Johnson. Are you in here?
Judge, I'm
Yes, ma'am.
sorry. Was this Mr. Mason? Was this Amadi Mason that we just did?
I just did Thornton.
Thornton. Okay.
5,000 and 100,000.
Okay, thank you.
Okay. Mr. Johnson. Johnson.
And I'm here for you, Mr. Johnson, Judge Attorney Taurus Butterfield.
Yeah. Terrence Johnson. He's not there yet. Roderick Nance. Jacoby Hudson here. There's Robert Nance. Oh, we're waiting on Mr. Hudson. All right. What about Amadi Mason? All right. They go 22 CP 212297, 91 days out of indictment. No bond as of September the 14th. Armed robbery, possession of a knife or a firearm during the commission of a felony, and theft by receiving stolen property. Rob.
Oh, there he is. No prior arrest, Judge.
All right, go ahead, Ms. Taylor. Ms. Taylor, you're on mute. Hey, driver, hit the little microphone.
Can you hear me now?
Yes, ma'am. Go ahead. Is he going to live in Decatur?
Mason, Judge, this is simply a young man, sadly, that was in the wrong place at the wrong time. I definitely presume to be innocent, and certainly we believe him to be innocent. Judge, he is 19 years old. He graduated from KIPP Collegiate Academy in May of this year.
Hold on, Mr. Mason. Mr. Mason. Okay, thank you. I'm just making, can you hear? Okay, go ahead. I'm sorry. I didn't know if he could hear. I could barely see him.
All right, Judge. Again, he's 19 years old, lives with his family, his parents. He graduated from KIPP Collegiate Academy this past May, May of 2022. Had taken all of his tests and done everything. Was supposed to have been enlisting in the United States Navy, Judge, in October. Unfortunately, he was in the wrong place at the wrong time with the wrong folks. There's no indication that I have seen that anybody has identified Amadi as robbing them. Amadi denies being involved in any armed robbery. Like I said, this is sad because he was headed to the Navy. No criminal history at all, Judge. Born and raised here. Like I said, just graduated from Collegiate Academy, everything. So I'm asking the court for a very reasonable bond. In this case, I believe an appropriate bond in this matter would be $25,000, a good bond. Judge, he did not have any weapon on him or anything illegal. And I don't believe anybody identified him as having been a person that was involved in any robbery. He's in this car with these other folks. And like I said, I think they said it was 3 guns in the car, 4 people in the car. Amadi did not have a weapon at all. So he will be staying with his parents, Judge, and unfortunately not able to pursue his Navy career at this point until gone. So we believe he's entitled to a reasonable bond. Nothing to indicate he's going to continue committing crime, that he's a flight risk, or that he's even in need of having an ankle monitor for that matter. Judge, he's basically going to try to find some type of employment until this case is over. Hopefully clear his name so that he can pursue what he wanted to pursue, which is going into the military.
Gentlemen, keep your seats. Sit down, gentlemen. Sit down, sit down, sit down, because I got to be able to see you wave. Sit down, sit down. We're trying to move as quick as we can. Miss Amjadi.
Bond was previously denied on September 14th on the basis that the defendant posed to. I apologize, Your Honor, my camera is off.
That's okay.
Bond was denied on the basis that the defendant posed too great a threat or danger to the community. Given the nature of these allegations, Your Honor, and the fact that the defendant was found in a car that matched the description of the car involved in the armed robbery within minutes, the state believes that in this case, a $40,000 bond for each one of the charges in this case is appropriate. Additionally, Your Honor, Mr. Mason is a co-defendant of, I believe it was Gerada Henderson. So as with Mr. Henderson, the theft by receiving stolen property was for a stolen firearm. Therefore, that charge should be a felony.
All right, you got any numbers?
$40,000 for each charge, Your Honor.
All right.
That's not what the co-defendant got, Judge, and I didn't hear what his record was, but again, Mr. Mason has no prior arrest at all. I don't remember what the co-defendant. I don't remember what the figures were, but it was not 40,000 per charge. It was less than that. That was the bond that was granted was less than that. And again, I don't know what his history was, but I know that Mr. Mason has no prior criminal history, Judge.
Well, Britain has no bond. Let me see. No drugs unless prescribed, no alcohol, no weapons, no further contact with Jaquavius, Jaquavious, Britton, Britton, Gerada, Jerada Henderson, DeMarco, Demarco Stringer, ankle monitor paid for by the county with a 24-hour curfew, court lawyer, and medical. You still gonna live in Decatur, sir? Thumbs up. All right. Stay out of Fulton County unless you're here for court or to see your lawyer. Don't stop gas in Fulton County. Don't get a flat tire in Fulton County. Stay out of Fulton County. Unless you're here to meet with Ms. Taylor, come to court. Stay away from 197 Lena. No further contact with the victim, Denard, Denard, Hillen, Hillin. 25, 10, and 5. 25, 10, and 5. Best of luck to you, sir.
Thank you, Judge. Y'all happy holidays, Judge.
Thank you. You too. Have a good holiday. Let's see. Terrence Johnson. Mr. Johnson. You can lay the booth, sir. Go ahead. Johnson. Last name. Oh, there he is. All right. All right. This is number one on one of the add-ons, Bostic. You found it?
Yep.
Okay. 1 second. All right. 22 CP 213811. Aggravated assault, possession of, excuse me, possession of a non-firearm during the commission of a felony or attempt to commit certain felonies, 35 days without indictment, and no bond as of November the 11th. Wow. Bostic, you're on mute. Go ahead. Bostic.
Second.
There you go. Oh, just a second. Okay.
Judge, in regards to Mr. Johnson, 16 prior arrests, open case 22 CR 22002085F for battery. 2 other misdemeanors. One was a 2018 reckless conduct that was reduced from an ag assault, open case in Cobb County for a Schedule 2 purchase, manufacture, sale of marijuana. Nothing further.
All right. Well, Mr. Butterfield.
Hey, good afternoon. May it please the court. Judge, as you stated, Mr. Johnson was arrested back on November the 9th, 2022, and he's been continuously incarcerated since that time. Judge, he adamantly denies the allegations of ag assault and possession of a firearm during the commission of a felony and seeks to vindicate himself upon trial. But we come before the court today and ask that a reasonable bond be set because, as the court can see, he currently has a no bond status. Judge, without getting into the merits of the case, I would like to give the facts as listed in the warrant as the court has read. The allegations are such that on September the 2nd of 2022, at or around 9:00 p.m., Zone 2 units were dispatched to a person armed fighting in progress at a Far Road address, and they met with the complaining witness, a Miss Neal. Miss Neal alleged that she said it was her boyfriend, that Mr. Johnson came to the apartment, that he burst into he kicked the front door, and then that he began to slap her, and then pulled a gun and pointed at her and said, "I'll effing kill you." And I guess when the police came, he was allegedly gone. Judge, Mr. Johnson adamantly denies these charges, and he tells me that he is right now a rising senior at Georgia State University. He is also an artist. I guess popular underground, is trying to make it mainstream. And he had requested that this young lady who he used to date stop posting photographs on Instagram, and that he was terminating the relationship. And that's why this call is made. Judge, I sent the court as well as over to Miss Amjadi and also Bostic, because I didn't realize it was Amjadi who might be handling this case at the time. But there are texts. If you, I sent it to Your Honor's email. Your Honor, this allegedly happened at, they say, between 7 p.m. and 9:57 p.m. Well, there are text messages that I submitted from that same day on September the 2nd at around 11 o'clock, in which Mr. Johnson and Miss Neal are texting, talking about meeting up. There is nothing in the text to suggest, "Oh my God, I can't believe you slapped me," or "I can't believe you put a gun on me," or "I'm hurt by what you did." These text messages continue on to the 4th, the 7th, the 8th, the 9th, the 10th, and the 11th. And most significantly, Judge, there are 2 videos I think that are telling in this case from the 12th of September, in which, if the court would watch those, and it's Miss Neal saying to the other followers, like, "He's with me right now, he's rubbing on my parts, and I'm the prettiest one out there," etc. So this was after this alleged incident. Now, this warrant apparently wasn't sworn out until September the 18th. So this doesn't seem right when you look at the it's one thing, I understand that people get back together after an incident, but there's never any mention that Mr. Johnson had done anything to this young lady. So we're asking that a reasonable bond be set, Judge. He does meet all the Ayala and Burge criteria. Although he's had some arrests, he's never had any felony convictions. I actually have been going to court with Mr. Johnson in the Cobb County matter. They're offering him a misdemeanor in that matter, but I've been with him since April. He's never missed court. So there's no reason to believe that he would flee the jurisdiction as far as the, factor 1 under Ayala and Burge, Judge. If released on bond, he will be living at 995 Forest Overlook Trail in Atlanta. The rest of the address is listed in the pretrial warrant, pretrial document, Your Honor. He's 22 years old. As I stated, he is, he's missed his finals, unfortunately, based on this arrest, but we expect that he should be finishing up school pretty soon, and he's pursuing artistry, and I think he is also studying music if he himself does not make it as the artist. But there's no reason to believe he would flee the jurisdiction, Judge. If released on bond, we would argue that there's not a substantial risk that he's a threat to any person or property in the community, nor is there a great risk that he would commit a new felony while out on bond. And I'll tell you, Judge, I've been helping Mr. Johnson on these apparently 2020 and 2021 is when he had never been arrested prior to these offenses that he has. I'm trying to get those things worked out, but there's no reason since April. We have been waiting on this Fulton County case. It has just been recently accused, and it's in Fulton County, the misdemeanor case. But there's no reason to believe he would be a threat to any personal property. And lastly, Judge, there's no reason to believe that he would intimidate witnesses or otherwise obstruct justice. We ask that a reasonable bond be set, Judge. In this case, I've been listening to the court on these different cases. We would ask that on the aggravated assault, And we'll be saying anywhere from 8 to 15,000 total bond, Judge, with any other conditions that the court sees fit. Obviously, no guns, no alcohol, no weapons, no contact with Miss Neal. I won't say her full name, and any other reasonable conditions that the court deems fit. But in this particular case, Judge, I would ask that the court and all the parties just take a look at the videos and the text messages that I sent over in this particular case, Judge. So that is what we have in this matter. We thank you for hearing from us, Judge, but we ask that a reasonable bond be set, Your Honor.
It's on Johnny.
This was one of those cases that had not been created due to user error within our own office's system. But I did, when searching for the defendant's name, I did find that he had a few prior cases with our office. The court previously denied bond because they found that Mr. Johnson presented a serious threat of harassment and intimidation to the victim in this case, that he presented a significant danger to the community and also a significant likelihood of reoffending. Your Honor, the state would like to reiterate these positions to the court and respectfully request that the court grant a bond amount that is commensurate with the seriousness of these offenses. And let's see.
I just sent you the emails, Mr. Butterfield.
I have not had an opportunity to review those yet, Your Honor. I do appreciate the court sending them to me as well. At this time, Your Honor, Mr. Johnson hasn't been in custody for very long, so the state would respectfully request that this case remain in no bond status so that the state may review the evidence that Mr. Butterfield has sent to us, and then perhaps we would be able to reach a consent amount.
Let me ask you a question, Ms. Amjadi. Are you going to be here the rest of the week?
I am, Your Honor.
So could you, do you think you would have a chance to look over it if Mr. Butterfield came back tomorrow or Thursday?
I think Thursday would be better, Your
Mr.
Honor.
Butterfield, can you make it Thursday?
I can, Judge, but I'll tell you, I've been on here since 5. I'll be happy to wait until, if it's a matter of reviewing what I sent her, I'll be happy to stay on all night to you. I know you all been working very hard with no break. So it looks like I'll get a little bit of a break, but I'll be happy to wait. But if you tell me to come back, Judge, we will do whatever this court deems fit.
Ms. Amjadi would be, because we still got some more and some of the people aren't in the booth, plus Lieutenant McDaniel's heart, he's probably out there pulling some too. So would that give you time though? Do you want Tuesday or Thursday, Ms. Amjadi?
Thursday, please, Your Honor. Thank you.
All right, Mr. Butterfield, do you want your client to be here or do you want to waive his presence?
Yeah, I would like for him to be here, Judge, please.
Okay, so we'll put you on then. Just so you know, we have to take Marion Annex, South Annex, and Cobb County first. So if you want to show up like 30 minutes later, whatever, feel free. So I just forwarded those to Miss Amjadi. She can look over them and we'll put you back on there. Miss Francis, you got that?
Yes,
Judge, and Miss Francis, would they send me Miss Fantasia, would they send me a new link for Thursday or will it be the same link, Judge?
You can use the same link, but I'm going to send out a refresher email.
All right. Well, thank you kindly. Your Honor, that's going to conclude my business for tonight. May I be excused?
Yeah, and I think it has, was it 5 emails or just 4?
I believe there are 4 emails, 2 videos, and the other 2 emails contain the text messages. I will tell Ms. Amjadi, I did try to reach out at that number I saw in the text messages, but I left a message. I didn't get to speak with anyone in case they try to reach out to see what the young lady's position is with regards to granting a bond.
Gotcha. All right, so we'll see you on Thursday, and it's the same one. Mr. Kane, pull over. When you pull over, you can come back. I got to kick you out. Got to treat you like I do everybody else because I will not be the reason you have a wreck. Thank you, Mr. Butterfield. I'll see you Thursday.
Thank you, Your Honor.
All right, thank you. So, Ms. Amjadi, are we ready on Contavious Wright?
Yes, Your Honor, I will be handling that.
Okay, so, Mr. Melnick has, go ahead, Mr. Melnick.
So, Judge, I don't know if I think I'd already sort of made out most of the case. He does have substantial family ties here to the community. He does have gainful employment waiting for him upon his release from custody. His girlfriend is currently pregnant with their child. He's only 24 years of age. I recognize, like I said, the serious nature of the offense, but he's been in for close to 120 days. He's statutorily entitled to a bond, and I would ask you to take that into consideration. We had asked for a $75,000 bond.
Ms. Francis, can you send a message to Mr. Kane? He's back in the waiting room. He is not to show back up in this courtroom driving down the road. Go ahead, Ms. Amjadi.
Probably aware this was a gang shooting where the victims were members of a rival gang to that of the defendants. Your Honor, criminal street gangs in Fulton County present a danger both to the physical safety of persons in the community and their property. They're criminal enterprises that by definition rely on the commission of crimes for their survival, and therefore their members and associates present an inherent risk of reoffending. This risk of reoffending is most relevant because it compounds the previously mentioned risks to safety of persons and property in the community. Additionally, witness and victim intimidation is a recognized pattern of criminal street gang behavior, and if released, the defendant and his cohorts are certain to threaten the safety of any witnesses and or victims in this case. I understand that at this point, Mr. Wright is legally entitled to a bond. If the state would respectfully request that the court issue a bond of no lower than $100,000 per count of the Gang Act charges here. The state would also respectfully request that the court supplement the bond order with the following special conditions: no contact with the victim, no contact with any witnesses, no contact with any members associated with any enumerated criminal street gang, no social media usage, 24-hour house arrest with an ankle monitor or precision location monitoring, Your Honor. No weapons and no replicas of weapons. Drug screens, and that the defendant stay away from the incident location.
Okay, Mr. Melnick, it's Peter Street. He is going to live in Mapleton, right?
That's correct, Judge.
Okay. All right. Let's see here. I got no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Dajuan, D-A-J-U-A-N, Jewel, J-E-W-E-L-L, and Philippiana, F-E-L-I-P-I-A-N-N-A, Sneed, S-N-E-E-D. No contact with J.J., that's a minor child, and no contact with, let's see, Dajuan, D-A-J-U-N, Jewel Jr. Have an ankle monitor or precision location tracking paid for by the county with a 24-hour curfew, court, lawyer, or medical. Stay out of Fulton County unless you're here to see Mr. Melnick or come to court. Don't run out of gas. Don't get a flat tire. Don't come to Fulton County, sir, unless you're going to the courthouse or to Mr. Melnick's office. Stay away from 498 Peter Street Southwest. You should absolutely have no problem with that since that's in Fulton County and you're going to stay out of Fulton County. No further contact with any gang members in any gangs, but especially 4PF, play for keeps. Oh, no, sorry, four pockets full. 4PF, 4 pockets full. Or rolling, or the Crips, or the Rolling 60s. This was a drive-by shooting. There was a 3-year-old. Do we know how the 3-year-old that shot in the head? Do we know the condition of the 3-year-old? Ms. Samjadi, I don't know. I don't see that. Victim's advocate.
Difficulties, Your Honor, and we apologize for that. Apparently the victim's phone number is disconnected. So we weren't able to speak to them, but we will put in a request for a victim locate, Your Honor.
Okay. All right. Yeah, because 3-0 was shot in the head, so I kind of want to see that.
Yes, Your Honor. And I think that's why there was some confusion about who was handling this, because on its face, it looked like a gang case, but with the child victims, it was actually assigned to crimes against children. But sometimes there's an overlap. Something may be listed that way, and then human trafficking will handle it.
Okay. And no driving during the pendency of this case. They out of Fulton County, sir. Cruelty to children. 3-year-old. You do have that presumption of innocence, but it's a 3-year-old. That's just heartbreaking. $150,000. $150,000 on each gang charge. $200,000 on ag assault. $200,000 on aggravated battery. Criminal attempt to commit murder. $200,000. 150. Then 150 on all those. 200 on just ag assault, aggravated battery, and criminal attempt to commit murder. Mr. Melnick, if you reach out and we find out there's something else, because it looks like allegedly one of the other people was a opposing gang member, whatever it's called. So if you find out more, please put it back on the calendar and we'll be glad to address it then. Best of luck to you, sir. Thank you, Mr. Melnick. Let's see, do we have, did Mr. Hudson get here, Kobe?
No, Judge, he didn't respond to my email. We may need to reset that case.
All right, yeah, and I don't have his number. Bostic, do you have his number?
Where are you looking for?
Jacoby Hudson.
Let me reach out to him if
you have his number. All right, and we've got David Chase.
Good evening, Your Honor. Marco Berger here.
All right. There he is. Finally. David Chase, 22 CP 212302. David Chase, 91 days without indictment. Aggravated assault, no bond. It's been 91 days. Wow.
In regards to Mr. Chase, multi-state offender, 5 in Tennessee, 2 in Alabama, 2 in Georgia. Open case 22 SC 182644. Felony obstruction, terroristic threats, 2 counts, criminal trespass, assigned to Judge Carnicella. Nothing further.
All right, go ahead. And is he going to be living in Nashville?
Now, Your Honor, since he's been here for 90 days, he's going to have to move back with his parents in Nashville.
Is that here in Atlanta or?
Nashville.
Okay, all right, go ahead, counsel.
Judge, as the court noted, this is the 91st day. He's entitled to a bond. The matter has not been indicted. He has no convictions, although he has some cycles. He does have the one pending case here in Fulton County, which the district attorney has asked me to plead him to a misdemeanor criminal trespass, and we have not. The case here is an incident that happened in the front door of the St. Regis Hotel. I have the video for the court's review if you want it. The St. Regis was kind enough to make me security.
Mr. Kane, stop. Mr. Kane, are you driving? Mr. Kane, you're going to have to pull over. I will not be responsible for you wrecking. Come back when you've pulled over. I can't do this. Go ahead, Mr. Berger. Sorry.
This happened on the front door of the St. Regis Hotel.
Right.
And there's ample surveillance video about, as you would imagine. The video is certainly somewhat different than the account given by the complaining witnesses. But nonetheless, be that as it may, he has no record of any convictions. He's entitled to bond. He will be living in Nashville. As the video indicates, and I think as was indicated in the first appearance, Mr. Chase got the worst end of it. The video shows he's the one who got his face smashed in when all was said and done, and there's a big pool of blood here and from the lobby of the St. Regis as a result of it. But we asked for a reasonable bond. Conditions of no contact with the witnesses is certainly acceptable to us. We have no reason for that. There's no reason for him to be here other than to see me. My office is not in Fulton County, so it's he can come across the river and see me whenever he would like. And we just asked for $25,000, and we'll be back to deal with these cases when the time is right.
Ms. Amjadi.
Thank you, Your Honor. On September 14th, the court denied bond on the basis that the defendant posed a danger to the victim and to the community. While it's true,
and Mr. Yarborough, I'm sorry, Mr. Yarborough is here, so go ahead. We'll hear from you if you'd like.
He is here and he would like to address the court, Your Honor. We have explained to him that at this point, the defendant is legally entitled to a bond. I would just like to note for the court that the defendant's criminal history spans 3 different states, Georgia, Alabama, and Tennessee. Let's see. Out of Georgia, Your Honor, there was a terroristic threats case and this aggravated assault case. While it may be true that the defendant sustained some injuries as a result of this incident, it's because he threatened somebody who was trained in hand-to-hand combat with a firearm. We would respectfully request that the court grant a bond no lower than $100,000 and house arrest in order to guarantee or provide some protective measures for the victim who is in fear for his safety. With that, Your Honor, may I please inquire of Mr. Yarbrough?
Sure. It looks like it says here that allegedly, Mr. Berger, that he says, Mr. Chase says, I ain't the one, all it takes is 7 pounds of pressure. It's incorrect. It's 5.3 pounds of pressure on the, it's 6.2. So it's not quite 7 pounds. Mr. Yarbrough, you want to take yourself off mute and raise your right hand? If you can hit that little microphone. There you go. You swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, sir.
All right. Thank you for showing up, Mr. Yarbrough. What would you like to say as far as bond? You know, and if you're
Yes,
in fear,
sir. I understand. Your Honor, I'm extremely afraid for my life. More so, I am terrified for the lives of my children. Mr. Chase has a history of coming after his victims. In Tennessee, the Tennessee law had to change because of David Chase, because he had a domestic violence charge, which anyone can Google, and was released early and immediately came after that victim. Mr. Chase did everything he could to kill me in front of my wife, 4 other people. And if you look at the videotape, I never hurt this man. He was holding one of my wife's employees against her will in a car. And then when she escaped the car, he came after me and repeatedly tried to instigate me. And I still never went after this man. If anyone else besides me was there, they would have a bullet through their head because of David Chase. And again, Your Honor, I'm afraid for my life. But I know this man has a history of coming after the people that he'd hurt. And I finally bested him and stopped him. I know he's coming after me. I am terrified for my children's lives. And I would plead with the court. He's going to live with this family. His father is the 2nd largest land developer in the state of Tennessee. The $100,000 is nothing to their family. I would like to request that for my children's safety, my family's safety, because now he knows where my wife works. Now he knows my name, that you give him $1 million cash bond because it keep my children alive.
Ms. Amjadi.
With precision tracking. I apologize.
Thank you, sir. Ms. Amjadi.
Your Honor, I would like to echo Mr. Yarbrough's request for precision location monitoring. As for an appropriate amount of bond, I did indicate that the state's request was that the bond be no lower than $100,000. I am not personally acquainted with the defendant's financial means, but if we have 24-hour house arrest and precision tracking, location tracking, then I think we can ensure some safety to Mr. Yarbrough and his family.
I did like Mr. Berger. This other case that he has here also happened at another hotel.
He was asked to leave the Lowe's, and the district attorney seeing fit to recommend to the court to plead to misdemeanor. We've indicated we don't want to do that. We've seen the video in that case. There's not a case there. And Judge, on this particular case, it's important to note it was Mr. Yarbrough who drove up to the St. Regis in a car and confronted Mr. Chase. Mr. Chase was sitting in a car with a service dog, and he came up, drove up to the St. Regis, jumped out of the car, and confronted Mr. Chase. We have no idea who Mr. Yarborough is. Mr. Chase has never met him, doesn't know. The only interaction they've had in this case is the fact that Mr. Yarborough came to the St. Regis to confront Mr. Chase, who was literally in front of the hotel with his service dog. He's on disability. He lives in Nashville. He was there to see me. Okay, his mom brought him down here to see me because he was having court with her the next day where we were asking for trial with Judge Carnesale. Okay, I don't know what's in Mr. Yarborough's heart, and I have no reason to disbelieve him. But at some point, we have to kind of look at the facts of this case. The reason why Mr. Yarborough was involved is because he drove up and came up on him. And I'm happy to show the court the video. I mean, it's the St. Regis. There's 15 different angles of this. You know, whatever, however it escalates, there's no audio. I don't know. That'll get sorted out in the case. But to try to make an example of him and to ask for bonds that, you know, because his family is wealthy while Mr. Chase is on disability is getting a little, I don't know how to describe it. You know, I'm not going to take up the court's time. It's 7:30. These are strangers on strangers. You know, we're happy to go away and not come back to Georgia or whatever the case may be. But he needs to get let out. He's entitled to a bond. It's the 91st day. If this was such a big, easy deal, I would imagine it would have been indicted already. But it's not.
Ms. Amjadi?
Yes, Your Honor.
You wanted 100, what did you want?
That the court grant a bond no lower than $100,000, Your Honor, and house arrest with precision monitoring.
No drugs unless prescribed, no alcohol, no weapons, no further contact with George Yarborough. Stay away from 88 West Paces Ferry Road. It's the Regis Hotel and any Regis hotels. No further contact with Makeda, Makeata, last name Jasmier. Stay out of Fulton County, sir. Only come back to Fulton County for court to see your lawyer. As a matter of fact, stay out of the state of Georgia. Unless you're coming to Fulton County for court or to see your lawyer, you're going to have that ankle monitor and precision tracking. You're paying it. It's on him, Miss Rowe. You're paying it with a 24-hour curfew, except for court, lawyer, and medical appointments in Tennessee. In Tennessee. Yes, Mr. Yorby, he takes up off bond. Statutorily, I have to give him a bond. Okay. Did you want to say something? You raised your hand.
You're on mute, Mr. Yarborough.
Sorry. Could you also add my wife, Brittany Alpert, to that list of people to stay away with? She's the manager of the St. Regis.
Brittany, how you spell her last name? Yarborough? Is it?
It's not Yarborough. We haven't legally changed it. It's Alpert, A-L-P-E-R-T. And unlike what his attorney said, I was there to pick her up, my wife up from work. She's afraid of dogs. Mr. Chase let his dog out, and I was at the door picking my wife up. You can see in the video. Then you see a woman run out of Mr. Chase's car, run to the building. Then Mr. Chase run at me, and I still did not attack him. He ran at me again and said, I only take 7 pounds of pressure. And said, I have 9 rounds in front of 5 witnesses, then walks off, then runs up to me an inch from my face, and then decides to pull up the 9mm Glock from his waist, grab it with both hands, and punch out into my face. With every attempt to take my life that he had threatened 3 times till he decided he's going to kill some unarmed black man in Georgia. Unfortunately, I've been trained in martial arts. If not for my martial arts training, my wife would have to watch her husband die.
Okay. So we'll put it's Brittany, A-L-P-E-R-T. So stay out of the state of Georgia, sir. You cannot come back to the state of Georgia unless you're coming to Fulton County. Drive straight through. Don't stay in a hotel. Don't stay overnight.
And Judge.
Yes, ma'am.
Is that Brittany or Brittany?
Brittany, right? Brittany, Miss Rowe.
Okay.
Brittany.
Okay. Let's see, where's that? And stay out of Fulton County, stay out of the state of Georgia. All right.
Can I clarify what the amount is?
One more time.
What was the amount?
Oh, I hadn't said it yet. And Miss Rowe, he's paying for this ankle monitor stuff, okay?
Okay.
All right. That'd be $150,000 good bond. Best of luck to you, sir.
Thank you, Judge. Might be excused.
Yes. All right. So, Mr. Yarba, he'll have that 24-hour precision tracking. Okay. So if he comes in the state of Georgia, he's violated his bond. Okay.
Thank you, Your Honor.
Yes, sir. Stay healthy and safe. Have a good holiday.
Thank you, Judge.
All right.
You as well.
All right. Yeah, we got Mr. Are you waiting on another one, Miss Rhonda?
I was just about to ask you if I could be excused.
Oh, absolutely. I'm sorry.
That's okay. Thank you. Have a great rest of your night.
You too. So let's see. Roderick Nance. Roderick Nance. So, sir, Mr. Hudson's not here, and Miss Amjadi's tried to get in touch with him. Any luck, Miss Amjadi?
No, no response, Your Honor.
All right, 74 days. So you've got no bond. It's only been 74 days, sir. So we will bring it back at the 1st of January when we get back, okay? All right, let's see. Bateman Hinton. Yeah, 2 cases. You ready, Mr. Hinton? Is that you, Mr. Hinton? All right, 22 CP 212351 Bateman Hinton. 89 days without indictment, possession of firearm by a convicted felon, possession of marijuana less than an ounce, possession of drug-related objects. There is a $2,000 split bond on that as of September the 15th. I've got 22 CP 212352, 89 days without indictment. There's aggravated assault and aggravated assault with a deadly weapon. No bond as of September 15th. Mr. Kane, on the system, it shows that there's a foreign warrant. That's all I know. You may want to check into that with a jail after this. Wow.
Judge, 18 prior arrests total. Prior 08 cocaine, 07 armed robbery, 2016 false imprisonment. Currently on probation for aggravated assault with a deadly weapon firearm by a convicted felon, 19 SC 172230. Sentence in 2020. 1 year confinement, 4 years probation, 1 FTA in 2018 to arrest for probation violation. Nothing further.
All right, go ahead, Mr. King. Can't hear you, Mr. King. It doesn't show you on mute, Mr. King. I think you may need to select the microphone. Go down to the little thing that says mute and select the right microphone. Mr. Kane? Oh, still, don't try to call him. Mr. King, that foreign warrant, it's out of Cobb County.
Can you hear me now, Your Honor?
I can. That foreign warrant's out of Cobb County, just so you know. So go ahead.
Yes. All right. And what is that? You said the first charges was a VGCSA?
So on that first case, it is possession of firearm by a convicted felon, marijuana less than an ounce, possession of drug-related object. There's a $2,000 split bond. Second case, it's aggravated assault with an object, then aggravated assault with a deadly weapon, and there's no bond on that.
Okay, so there is a bond on the first case.
Split bond, except for there's no bond on possession of firearm by a convicted felon.
Split bond. All right. It's 7 grams of marijuana and a scale. So, all right, let me tell you about the aggravated assault. There's 2 counts. You have to read between the lines, but a girlfriend named Chandria Boyd said that Bayman Hinton owed her money and that she had an argument with him on on March 22nd of this year, 2022. She said they had an argument about the debt and that he took her car and left her and then came back and brought her car. Sometime thereafter, Miss Boyd, called the police and said, count 1 aggravated assault on March 13th. They had an argument and he hit her He hit her in the head, maybe with an object. But she said she didn't go to the doctor. There's no police report, no medical records. So this is on March 22nd. She's saying there was an ag assault on March 13th. And she also said on March 16th, she's saying on March 22nd, on March 16th, he pointed a gun at her and threatened to shoot her. She also told the police they were arguing over money. So it's a pretty questionable case, and there's a lot of credibility issues, real serious credibility issues. Like, why would you wait a week or two to call the police? You said this happened, and you knowingly admit that you're arguing over money, over a debt. So I'd ask you to set a bond, say $10,000 on each ag assault and $5,000 on the prior firearm possession.
Jotty.
Your Honor, as Officer Bostic indicated, the defendant's criminal history covers quite a few offenses. We've got possession of a firearm during commission of a felony from 2008 out of Gwinnett County, 2010 drug conviction, the 2007 armed robbery, a 2016 false imprisonment, and then the case for which he's on probation right now, ag assault with a deadly weapon, and possession of a firearm by a convicted felon. Your Honor, under OCGA 1761, subsection E, subsection 3, when a defendant has previously been convicted of a serious violent felony, which under 1710 armed robbery is one, then there's a rebuttable presumption when he's charged with another violent felony that no condition or combination thereof can reasonably assure the safety of the community. Given that, Your Honor, the state does not have a recommendation with respect to bond because given the fact that the defendant is listed as an APD repeat offender and has a number of serious violent felonies in his history, as well as firearms in both of these cases, and aggravated assault charges in one, the state's position is that no bond amount can guarantee the safety of the community from this defendant.
All right, no drugs unless prescribed, no alcohol. Okay, count one, no drugs unless prescribed, no alcohol, no weapons. 15,000 on count one, count two and count one, I'll leave as previously decided, 1,000 apiece. On position 19, ending in 2352, no drugs unless prescribed, no alcohol, no weapons, no further contact with Chandrika, Chanrika, Chanrica, last name Boyd, Boyd. Stay away from 349 Cleveland Avenue Southwest. And stay away from 722 Terra Circle Southeast. Have an ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, medical, employment. Sir, you just have to give the name of your employer, location, proof of employment, a schedule. We have to give it to Mr. Kane. We'll then turn it over to the state. You also have to let the ankle monitoring company know where you're going. Shut down. $50,000 on each count. Best of luck to you, sir. Mr. Kane, all I have in a number for that warrant is, let's see, Cobb County, and the only number that's on here for it is 741161. 741161 from Cobb County Sheriff's Office. I don't know if that number helps you, but best of luck to you, sir. Thank you. Best of luck to you, sir.
Yeah, be excused.
Yes, sir. Have a good day.
Yeah, Merry Christmas. Thank you.
Let's see. Okay, somebody just said something in there. Where it say Justin Hayes. Jamel Romeo, if you want to start your camera.
Your Honor, I believe he was the victim in one of
Justin
the,
Hayes, we already did that one.
Yeah, well, I was going to tell her what it was. Jamel Romeo, could you start your camera? And turn your camera on.
Hello, I'm trying right now. I don't know if you can hear me.
I can hear you, but I kind of need to see you.
There's
There
the
you go.
camera.
Okay. So he was granted a $60,000 good bond. No further contact with you. Ankle monitor with 24-hour curfew. He can leave for court, lawyer, medical. No drugs, no alcohol, no weapons. No further contact with Kingston. Stay away from 680 Murphy Avenue. Stay away from 2727 East Point. Did I put stay out of Fulton County unless he's here for a court or to see his lawyer. And he'll have an ankle monitor on. They'll be monitoring his location.
Yeah. I got the thing late, Your Honor. I would have definitely opposed to that. As the gun was pointed at me and my son jumped in front of the gun and the man is in a bike gang, motorcycle gang. Like, this is just crazy for like people to do whatever they want and just get out and be able to still react or do whatever. I don't know where the lack of communication is from the court, Your Honor, but
For me,
I got not
I don't handle all that.
not from you. I got the text extremely late and tried to jump on and was having problems.
I think maybe the victim's advocate should have done that, but
Yeah,
I'm sure
it have been done a day before, Your Honor, not like in the process of, not disrespecting the court, but it's crazy. My son is 10 years old. He's in therapy. I'm actually fighting family court now, spending a lot of money on family court just to protect him because his mother is with this person.
Well, we told him to stay away from, is it Murphy Avenue where she lives?
Your Honor, if he pulled a gun out in front of you and your son or your child jumped in front of you, do you really think he cares about anything and told my son to be a dead dad?
Well, that's why he has the ankle monitor. If you see him anywhere around there, sir, please do that. Ms. Amjadi, do you want to give him the name of someone that he could reach out to complain that he didn't get his Zoom link until later?
oh, yes. I apologize, Mr. Romeo. My victim advocate has been having some technical difficulties with her laptop this week. Can I have her give you a call tomorrow?
It doesn't matter. It's pointless now. It's really pointless. I mean, you guys tell people to speak up and report to the cops. It's pointless. It really is pointless. I have a kid that's in therapy that's been traumatized over this situation too. Like, he's physically in therapy.
Well, I'm sure he's very lucky to have a proactive father.
No, but he's not lucky. System protecting him. I should have been notified a day before. I should have been notified. Not 20 minutes of in a text. I have the text the time you guys notified me. And by the time I realized you guys notified me, I jumped on the Zoom.
I apologize for the late notice, sir.
Mr. Romeo, feel free to reach out to, she could give your number or whatever to someone. And I do want you to address that because trust me, I want the victim's advocates here myself. Yeah. That's why I always ask, because anyone spoke for the victim. So I want you to do that. Sir, you also have the option of, and I'm sure Ms. Amjadi is about to tell you to get a protective order. He's in Fulton County. You can fill that on the 8th floor at 136 Prior Street. And that would keep him away from you, everybody else. If he comes within 200 yards of those, then obviously he can get arrested for aggravated stalking because he can't go to her house or be around him. So if your son tells you that he's been around here, you need to let the DA's office know. They can revoke his bond. If you have a protective order, he can get charged with aggravated stalking, which carries up to a 10-year service. 10-year sentence.
Thank you, Your Honor. Do you still need me, Your Honor, or can I be excused? There's really nothing I can.
I want to help you, sir. I can't, who does he need to talk to, Miss Amjadi?
Miss Derica would probably be the best
I
person.
mean, there's nothing.
Chandrika.
East Point Police Detective did his job. This situation took a long time for them to get the guy. There was lying involved from my son's mother, lying. The cops were called. Everything was done right by me, trying to protect myself and my son. And you guys dropped the ball. Like, I've been cooperating every time you guys notify me.
And we do appreciate that.
This crime is so outrageous in Georgia. It's just ridiculous. It's no accountability for anything. There's no accountability.
We'll leave it up to the DA's office. Oops, sorry.
Head of the Victim
Right.
Justice Program.
Yeah, I think we're finished. We're finished with the stream. Do we need anything else?